Fourth, my lord. Fourth of
I beg to mention item number 30, my lord. 30. That case diary is also not here, my lord. Team is there. 30.
Heard Mr.
Yes, Rana.
S. Rana, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this matter be listed again on
Team is there, my lord.
next
December.
December
Second week. 2012.
on 20 December 2023. The interim order shall continue till next day.
May I please, your lordship. Lordship, I beg to mention for listing of an interlocutory application, lordship. Today itself, lordship, because the connected industry bail application has been listed inadvertently typed out in the petition and cost title. So lordship was on the earlier question directed to me to file one appropriate application. I have deployed, lordship.
May I please, your lordship, I beg to mention item number 36, my lord. Kindly pass over the matter for today. CD was called for, but it's not available. my lord.
Heard Mr.
A was Sumatari.
A. Basumatari, learned counsel for the petitioner, who prays for an adjournment. Also heard learned Ms. S. Jahan, learned public prosecutor, additional public prosecutor, who submits that the case diary has not arrived and prays for another date for producing the same. The prayer is allowed. Let this case be listed again on.
Friday, my lord, if possible. 1st December.
You are on interim.
No, my lord.
Okay.
I'll give it.
4th
of December.
definitely on 4th of
4th, Monday.
Obliged, my lord.
4th of December.
Roll item 1.
Yeah, it's action from the.
Are withdrawing?
Yes.
Heard Mr.
Yes,
S.
Rana.
Rana, learned counsel for the petitioner, who submits that he has instructions from the petitioner to withdraw the instant criminal petition. Considering the also learned additional public prosecutor. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This case is dismissed on withdrawal.
Liberty will be get.
The petitioner
That
seeks
is always there.
what liberty? You are challenging an order,
Yes, but
They-
and I access.
then 7, no liberty. Liberty is already there.
Hmm.
We need not to mention it.
Obliged.
For motion item 2,
Before that, Mr. Chaudhary, your matter is not listed today. Whether cause list has
Cause these also cannot come.
from Kohima,
I don't know. Because I checked in the net, it's not there.
we have asked them you have inquired. If the cause list is published even before 2, we will take it up. Otherwise, we will fix another day.
It's not there for tomorrow.
Okay, at 2 we will see.
Yeah, no problem. That if today is going good, if not,
So at 2 we will pass out.
item 2,
May I please, your lordship? My lord, 439 application, my lord. Petitioner was arrested on 10/11, my lord.
10, 11.
11, already 18 days behind the bar. My lord, kindly please the allegation at page
How many
13,
days?
My lord, my lord,
How many days?
18 days, on it. My lord, allegation at base 13, my lord.
Yes. CD would be required.
Lordship, yes, there is a kidnapping charge, not payment of
My
money.
lord, victim also recovered, my lord, fact is, my lord, the
Case diary would be required.
the husband of the wife, my lord, have taken 3 lakhs rupees, my lord, with the condition to supply 20 number labor to the big industry, my lord. All money is misappropriated, my lord. On the LSD, my lord, the informant, the petitioner caught him and brought to the Tripura, my lord. No
Oh,
kidnap, my
oh,
lord.
Let us go through the case.
My lord, very short date, my lord.
Heard Mr.
Till the Sabbath, RLE.
R. Ali, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional prosecutor. Considering the nature of allegations leveled in the FIR, the result of the case diary would be necessary, hence call for the case diary.
12th of December, Dhubri.
Fixing 12 December for case diary.
Obliged.
3,
My lord, in this case, when I pay for sitting, I will call for my lord. I'm in custody for 48 days, my lord.
Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional prosecutor. Call for the case diary. Fixing
On 4th of December, like, our other like,
4th of December.
today is 24th.
Azra, please.
4th of December for case diary.
Obliged.
item 4,
Very please, your lord, my lord. In a similar case, granted bail, it's the order, exactly similar. He's also police informer, my lord. He's also reference is that, my lord, ground is that, my lord, he was with the police, he was with the team led by the Germany Rava. And one co-accused paid rupees 40,000 in his bank account. His allegation. His earlier real was earlier order.
Lordship, the I of this case would like to file an objection to it, Lord.
Let him file on it. Whether case diary would be required or only objection would go.
Objection is good.
Heard Mr. F.K.R. Ahmed, learned counsel for the petitioner. Also heard Mr. M. Haloy, learned special public prosecutor, CBI. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Mojibur Rahman, who has been detained behind the bars since 2/6/2023 in connection with PRC case number 1626/2023. Learned counsel for the petitioner has submitted that the co-accused, how many co-accused were?
Three, on 22, three co-accused were released.
Three co-accused have already been granted bail by this court, and on the ground of parity, he prays for allowing the present petitioner to go on bail also. On the other hand, learned special public prosecutor CBI has prayed for allowing the CBI to file
Written objection.
a written objection against the prayer for bail made by the petitioner. The prayer is allowed. Let this matter be.
On 8th of December.
Before that, he will file.
Yes.
Let this matter be listed again on 8th of December. The petitioner may, the respondent CBI may file written objection before that day,
On or before that.
on or before the next date fixed.
Value.
item 5,
The council is not there. R.K. Singh.
Case diary would be required.
Case of theft, in fact, a gang of thieves were arrested and number of things were found, so it's very. Case Juran Ali,
None appears for the petitioners on call. However, none appears for the petitioners on call. So I've heard Mrs. Jahan, learned additional public prosecutor, who submits that considering the nature of offense involved in this case, the perusal of case diary would be necessary. Hence, call for the case diary. Fixing
on 6th of December,
6th of December for case diary.
item 53 of the supplementary list,
My pleasure, Lordship. Lordship, illustration is 376, 120B, Lordship. It's a mutual relationship, Your Lordship. Is number 8 is Lordship. Annexure 1, Your Lordship. Only one sentence, Your Lordship. Beginning since last 3 years, the accused number 1 established physical relation with me on several times by inducing. Since 3 years, your lordship, the physical relationship is going on, your lordship. A small FIR, your lordship, is number 8, your lordship. Protect.
Although that rape part is there, but then she said, thereafter he took me home on the promise of marriage. And accused other, these must
How
be the
many,
family
how
members.
many days you are there?
Lordship, on 20th November, lordship, I was arrested, your lordship. On 2nd October, your lordship, FIR was filed, your lordship. Thereafter, on 7, your lordship, after 5 days, your lordship, it was registered, your lordship, by filing a complaint before the SP, your lordship, case number 13, your lordship. Initially, no
Let
cases,
us-
that's why
let us
earlier,
Go through the case, then, fixing it shortly.
it's a mutual relationship, your lordship.
No, there is allegation of
76
rape also.
is not there, your lordship.
Heard Mr. R. A.R. Karim, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of an offense involved in this case, the perusal of the case diary would be necessary, hence call for the case fixing.
On 6th of December,
Obliged.
Item 7,
May I please? My lord, we have challenged the, my lord, FIR as well as the, my lord, search sheet. Lordship will find, my lord, the FIR at page 14. And my lord, the particular portion, my lord, page 60.
Yes.
Now, the, my lord, order passed by the, my lord, learned court below, lordship will find at page 20, whereby, my lord, he was released on bail after 7 days in custody. Page 20, my lord.
Now, on what ground you are challenging the affair?
Because, my lord, the primarily, my lord, the statement of the victim as revealed from the order sheet of the learned magistrate, my lord, would, my lord, go to show that there is no case made at all. Because of that, my lord, he was granted, my lord, regular bail by the learned court below. That is the, my lord, only source of it. But the 164 statement, my lord, and the, my lord, search sheet has not been furnished to the petitioner, despite the, my lord, application filed by him. Lordship will find at page 23.
164. What is that?
What was the allegation?
Allegation is, my lord, 376 and, my lord, section 6 and 7 of the POCSO Act.
Yes, Ms. Jahan.
In fact, FIR does show elements. She is a minor. He is a married person. He is a advocate too. And he was in fact given one chance, but later on he again did the same thing with the minor. So allegation of POCSO is well meted out in the FIR. And 164 statement, where is that? In fact, for a sec. Huh? 164 statement he has not annexed, but then only the averment given in the order.
That she
In
has
the order
not-
sheet.
Mainly because the victim remained silent.
Uttered any single word against the accused. She is a minor, she must have been threatened. Anything can happen. The victim and her father also appeared today after receiving notice, and both of them have raised no objection in respect of the instant bail application. It is seen that the accused is an advocate by profession, so there is no chance of absconding. This is as far as bail. Those contentions will not affect here. Let us see 164 statement, because this is only a it is being written by the
Apart from 164, there may be other material.
other materials also. And otherwise, the FIR shows the gravity of offense.
No, when the FIR discloses the offense clearly, then on what basis you are telling?
Now, affair says, my lord, affair lost by the my lord third party, saying thus, my lord, extramarital affair.
Hmm.
That is the my lord, foundation of the case, my lord. Now, what is the my lord, prima facie case against the petitioner in view of the statement under section 164? That is the my lord, core issue.
You are on bail.
Yes, he is on bail.
Let us call for the.
Not the scan copy of the or
Third, Mr. N.U. Mandal, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Maqbul Hussain, praying for washing the. What is your prayer?
Prayer lordship will find at page 7 minutes.
Washing the proceeding of Gosaigaon PS case number 290/2023, which was registered under section 376/504 of the Indian Penal Code on the basis of the FIR lodged by one Muhammad Hassan Ali on 25th of July 2023. The learned counsel for the petitioner has submitted that the FIR has been lodged by a third party, whereas the victim herself in her statement recorded under section 164 of the Code of Criminal Procedure has not implicated the present petitioner in anything. However, learned additional public prosecutor has submitted that as the FIR clearly discloses the offense alleged against the present petitioner, perusal of the case diary along with the statement of victim would be necessary. Hence, call for the scan copy of the case. Call for the scan copy of the case diary.
charge sheet to one.
Charge sheet.
Was it?
You have challenged the charge sheet also.
Oh, yes, charge sheet.
Call for the scan copy of the PRC case number.
My lord, charge sheet number is my lord, given, my lord, 306/2023.
You don't have the PRC case number.
Yes. Yes, case number.
Scan copy of the
Yes.
case diary of Kokrajhar PS case number
Yes.
290/2023, along with the charge sheet. Scan copy of the charge sheet number.
Charge sheet number, my lord, 306/2023.
306/2023 dated from the Court of Learned.
My lord, their case is there, my lord. Their case number is there, my lord. 318/2023.
And copy of charge sheet number 306/2023 corresponding to GR case number
318/2023.
318/2023 from the Court of Learned Special Justice Kokrajhar. The registry shall take steps for requisitioning the scanned copy of the case report are called for. Let this case be listed again. And issue notice to the opposite party. As learned additional public prosecutor has appeared before respondent number 1, no formal notice need to be issued to the respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps as for service of notice on respondent number 2 as per the mode prescribed by this court in Deepak Nayak versus State of Assam. Let this case be listed again on
8-1.
8th of January.
8th
That
of
is-
January.
Victim is also made party in the. Respondent number 3.
Respondent number 2 and 3 instead of respondent number 2. Respondent number 2 and 3 as per the mode prescribed.
Developers.
Item 8,
Yes, your lord. In this case, what is petition is paying for washing the NBW issued against him, lordship. Lordship, whatever lordship, page 23, lordship.
Page
23, lordship. Lordship, petitioner takes steps, lordship, on 18/3/2023, then 18/5/2023, and on 18/5/2023, matter was fixed again wrongly fixed on 18/5/2023. Therefore, lordship, due to this wrong fixing of date, lordship, petitioner could not get the appropriate date at page 24, lordship. The
No,
Okay,
no, I'm not getting you. On 18/3/2023, what happened?
he has submitted an application for an engaged counsel for appearance, lordship. Accused is absent with step fixed on 18/5 for appearance. Then 18/5/2023.
Oh, the same date was
Same.
reflected again. Nikki,
Yes, lordship. And the matter was fixed again on the same date, lordship. Because of the wrong fixing of date, lordship, the communication gets lordship, and then matter was fixed on 27/2023.
It's without
page
any
24.
step.
Lordship, then NBW issued, lordship. So my lord, he is will appear, lordship. Kindly.
He has a case.
No, previous 18/5 was written wrongly. Let him go and appear within
Lord.
10 days.
Lordship. MS
Mr. A.M.S. Majumdar, learned counsel for the petition. Also heard Ms. S. Jahan, learned additional for prosecution. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Shri Vinod Roy, alias Vinod Roy, for setting aside the order dated you have not mentioned this 18th.
Lordship, page 24 is the date. And in the
In the prayer portion,
prayer also, lordship. There was
setting
a
aside
stated
the
that-
order dated 27/2023, 4/8/2023 and 3/10/2023, whereby non-bailable warrant of arrest were issued against the present petitioner by the learned additional chief judicial magistrate Kachar in PRC case number 978/2019. Learned counsel for the petitioner has submitted that on 18/3/2023, the PRC case number 978/2019 was fixed before the court of learned additional chief judicial magistrate Silchar Kachar. And on the said date, the petitioner could not appear before the learned trial court. It is the committal court, learned committal court, and he engaged a counsel to show the cause of his absence before the learned committal court. On that day, the next date was fixed on 18/5/2023. On 18/5/2023 also, the petitioner remained absent with steps showing cause of his absence. However, on 18/5/2023, the court fixed the next day, again on 18/5/2023, which according to learned counsel for the petitioner resulted according to learned counsel for the petitioner might be due to typographical mistake. However, he was not aware of the next date fixed, and the case was again put up before learned trial court on 27/2023, on which date on the state date the petitioner was absent before the learned committal court, as he was not aware about the date next date fixed, as on 18/5/2023, no mention about the date 27/2023 was made. It is further submitted by learned counsel for the petitioner that on 27/2023, learned committal court issued non-bailable warrant of arrest against the petitioner. However, it is submitted that the absence of the petitioner before the learned committal court was not intentional. It was only due to the communication gap due to wrong mentioning of the date in the order sheet itself. Learned counsel for the petitioner further submit that the petitioner is ready to appear before the learned committal court. However, due to the pending warrant, due to the pending non-bailable of warrant issued against the present petitioner, he is apprehending that he may be arrested. Stop. When is the next date? Learned counsel
25.
for the petitioner also submits
5/2024.
that PRC case number 978/2019 is next fixed on
Page 25, my lord.
5/1/2024, and he is ready to appear before the learned committal court on the said date. Learned additional public prosecutor also does not oppose this the prayer of the petitioner to facilitate him from appearing before the in appearing before the learned committal court on the next date fixed. In view of the submissions made by learned counsel for the parties, and in view of the fact that apparently there was a mistake of mentioning of date by the learned committal court on 18/5/2023, the petitioner, namely Vinod Rai, alias Vinod Roy, is hereby directed to appear before the learned trial court on
5/1/24.
5/1/2024, and to facilitate his appearance before learned committal court, the operation of non-bailable warrant of arrest issued against him by the learned committal court shall be kept in abeyance till 5/1/2020. With this observation, the instant criminal petition is hereby.
Item 9.
My lords. My lord, the petitioner before your lordship was, my lord, the executive engineer, my lord. And in the meantime, my lord, he has retired from service, my lord. He is praying by this application under 482 CRPC, my lord, for quashing of one FIR, my lord, placed against him. And the relevant portion of this FIR at page 8, my lord. Page 38, my lord. Here, lordship, kindly have a look. It is stated that, my lord, to the officer in charge, come superintendent of police, vigilance and drinking water. My lord, it is Deputy Superintendent of Police, my lord, vigilance and anti-corruption, Assam. FIR lodged by lord dated 17 January 2022. With reference to the subject cited above, I have the honor to report that as entrusted, I have conducted the aforesaid referred preliminary inquiry which was initiated by letter number so and so dated so and so against the Kishore Bhattacharya, Assistant Executive Engineer, Civil, PWRD, for his alleged involvement in misappropriation of rupees 49 lakh from government exchequer during his tenure as in charge executive engineer civil, Maibong Roads Division, and upon an inquiry report from the issued submitted by Sri Jatin Urua, the then additional chief engineer, civil PWD Hills, Haplong, Assam, citing that due to non-cooperation and avoiding nature of Sri Kishore Bhattacharya, he could not determine the quantum of amount that has been misappropriated by Sri Kishore Bhattacharya. However, he found that there was no record in the official cash book regarding receiving of government money during the period of 1/3/2013 to 7/7/2013, and also failed to maintain any record related to plotting of tender issued of work order, budget or estimate of work, etc. During inquiry on scrutiny of the available record, it is found that Sri Kishore Bhattacharya, Assistant Executive Engineer, Civil Service, while holding the post as in charge executive engineer Maibong, during his issue bank checks from government exchequer to various persons without any functional or other work keeping in the account and cashiers of the office in dark, and by kept the account file to of the checkbook with him. He never maintained any record of such transaction in any correspondent file. During examination of bank statement, it is found that Sri Kishore Bhattacharya has misappropriated. This is important, my lord. An amount of rupees 3,262,194 rupees from the government sector by abusing the official power and position. On the above findings of the report as submitted to the government, was pleased to accord approval to register a criminal case against Kishore Bhattacharya by letter number so and so. Now, Lordship, kindly will look against this, my lord, factual aspect of the FIR. This honorable court, my lord, while granted bail, this, my lord, fact and figure was found incorrect, my lord. Page 40, my lord. I beg to refer, my lord, the relevant portion of this paragraph, my lord, while granted bail, my lord. Paragraph 5, my lord. Contrary to the statement contained in the FIR, page 40. Contrary to the statement contained in the FIR, the learned counsel for the petitioner has referred to letter under number so and so, dated so and so, enclosed there is the observation of inquiry officer dated 7/7/2017, wherein it is mentioned that the petitioner was holding the charge of executive engineer PWD Maibong so and so division from 8 to 2013 and handed over the charge on 21/5/2014 to the next incumbent. From the order dated so and so passed by this honorable court in WTC number so and so, it is, my lord, regarding his, my lord, reinstatement to the service, my lord. It appears that the petitioner was under suspension by notification number dated so and so, which was last extended by speaking order dated so and so. So, my lord, all along, my lord, he was in, my lord, in suspension, my lord. But this misappropriated period, my lord, noted in the FIR, my lord, this is not the period while my petitioner was working, my lord. And regarding my lord, accordingly, my lord, this honorable court was pleased to my lord grant him the bail, my lord, interim bail followed by the absolute bail order, my lord. Now, lordship, I beg to show my lord page 44, my lord. My lord, more than what they alleged, my lord, during that his period, my lord. Page 44, my lord. Here, my lord, there is a committee, my lord, for payment of compensation to landholders, my lord. And committee, my lord, this revenue department, my lord, submitted the demand, my lord, to the department, my lord. Page 44, Annexure 11, my lord, for compensation in respect of land acquisition from my lord that Hinga 0.2 half long town for road development of.
No,
Two-
what is this?
My lord, this is my lord demand, my lord, furnished to the department, my lord. Before my lord, joining of the petitioner to the department, my lord, and it was lying with the department, my lord. That much, my lord, land acquired by the department, my lord, for developmental scheme, my lord, and this revenue department, my lord, and its committee made this recommendation to pay those amount, my lord, more than my lord 3 crore 74 lakhs 25,589, my lord, to the my lord landholders, my lord, and accordingly, my lord, this my lord, all the checks were my lord issued. My lord, I have annexed, my lord, page 46, then page 47, then page 48, then page 49. My lord, some other text, then page 50, my lord. And all those texts, my lord, petition are issued during, my lord, a small period while he was working, my lord. But he, my lord, joined 2013, my lord. In the beginning of 2014, my lord, he was, my lord, suspended. And accordingly, my lord, he remained all along in the suspension, my lord. And while, my lord, he was just, my lord, reinstated, immediately, my lord, he was given superannuation, my lord. That about, my lord, lordship kindly able to, the major, my lord, allegation, they are noted. These are, my lord, apparently, my lord, baseless. How, my lord, lordship kindly will look his suspension order, page 14. Page 14, my lord, Annexure 1.
No, what is your basis for
Basis, my lord,
that the period which is shown in the FIR?
I was not there, my lord.
You were in suspension.
Yes, suspension, my lord. And my lord, basic allegation they furnished to me, my lord, in the departmental proceeding, page 18, my lord. Page 18, it is, my lord, they are charged, my lord. Here, my lord, they themselves saying that, my lord, I issued check, but there was no, my lord, balance in the bank, my lord. If, my lord, I issued check, my lord, balance is not there, my lord.
Departmental proceeding is different.
Different, my lord.
Then let us issue notice. You are on bail.
I'm on bail.
In fact, the period that is mentioned in the FIR
It's
is
only for
from,
not maintaining the records properly.
but then the allegation of misappropriation, it is during the period from March 2013 to August 2017.
That period is not regarding allegation of misappropriation.
No records.
That is not maintaining proper record.
No, this is a
Or-
consequence to the main allegation. Because initially they say there was an alleged involvement, misappropriation of 49 lakhs. Due to so this period they could not ascertain the earlier inquiry. He could not determine the quantum of amount. However, he found that there was no record in the official book receiving money from so-and-so to so-and-so.
And my lord, how he, my lord, as per FIR, my lord, concluded then this much is misappropriated, my lord. Earlier, my lord said, my lord, I should check that
No.
much, my lord, 49.
So something has been alleged against you.
Yes, sir. Of course.
You cooperate in investigation, truth will reveal itself.
He did not do in the first inquiry, so they could not ascertain the quantum. And he retired in September. He was put under suspension on 11 September 2015. So there is around 2 years or so when he did not keep the records for which they allege there is a misappropriation.
And in the bail order, my lord, it is mentioned, my lord, the period
No, that was for the purpose of granting you bail.
That will not affect the,
No, this is factual.
Present
I'm
case.
just on fact, my lord, not other. Handed over, my lord, on 21/5, my lord, 14, my lord. I was already released, my lord, from this court, my lord.
Okay,
And-
let us go through the case that
okay.
we'll issue notice. Who is Nizamuddin Khan Chodri?
He's the informant, I think. Nizamuddin,
He will
yes.
be
No,
representing
I'll represent. He is the DSP.
Mr. A.M. Bordhuya, learned counsel for the petitioner. Also had Ms. S. Jahan, learned petitioner for this application under section 482 of the Code of Criminal Procedure, 1973, has been filed by Sri Keshalaya Bhattacharya, praying for setting aside and quashing the proceeding of ACBPS case number 3/2022 under section 403/409 of the Indian Penal Code, read with section 13 within bracket 1 within bracket small a of the Prevention of Corruption Act, 1988, which was registered on the basis of an FIR lodged on 17 January 2022 by the respondent number 2, namely Nizamuddin Khan Chaudhary, Deputy Secretary
That's
of
okay.
Vigilance, Anti-Corruption Department, issue notice to the respondent and call for the case diary of ACBPS case number 3/2020. As learned additional public prosecutor appeared for both the respondent, no formal notice need to be the respondent side. List this matter after 4 weeks. After 4.
Interim order may be considered on perusal of the case that one.
He's already on bail, so.
What interim?
My lord, I am praying for, my lord, staying the procedure, my lord, the proceeding.
Harshi to Hane?
There is no urgency for it.
My lord,
List after 4.
Gotcha.
I'll find any date maybe then.
10-1.
Diploma.
Item 10,
24.
Yeah, please, Your Lordship. 438 application also. Yeah, you will find the FIR page 18. The Assembly's one. Page 18, 1A. Primarily, the allegation is against 3 persons, Lordship. But in respect of petitioner number 3, there is no allegation in the FIR. Though there is some allegation in respect of petitioner number 1 and 2. So at this stage, Lordship, I am not pressing for anything except in respect of petitioner number 3, Your Lordship may kindly protect the petitioner number 3. In respect of 1 and 2, I am not pressing for any interim order. Lordship.
Manwara Khattu.
Manora Khatul. There is no allegation. May I read the FIR?
What is the gist of accusation? What is the allegation? in the FIR?
The allegation is that Lordship, petitioner number 1 and 2, they went to the house of the deceased, called him out, and they slapped him. And then in the meantime, he consumed poison.
Slapped him
Yes,
or stabbed?
slapped, Lordship.
Slapped.
Yes.
And against Manwara Khatun?
There is no allegation, Lordship. The only statement in the FIR against Manora Khatun is that he informed the informant that the deceased consumed poison.
Manwara Khattu only that she returned back and informed her daughter-in-law
Yes, that is the only.
that Nawab Ali consumed poison and he had
Perhaps
rushed.
Not an allegation.
I don't know, so.
It's just a statement. Actually, petitioner number 1 and 2, they incurred all the expenses.
Or Mr. R. Bora?
Lordship.
Let her appear.
Not
Lordship.
Heard Mr. R. Bora, the counsel for the petitioner. Also heard Ms. S. Jahan, the additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Saheb Ali, Sirazul Ali, and Manwara Khatun, who are apprehending their arrest in connection with Deung Muk Police Station case number 16/23 under section 294/306/323 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 4/10/2023, one Muhammad Joygan Nesa had lodged an FIR before the officer in charge of Greenwood Police Station, inter alia, alleging that on 18/9/2023, the petitioners, the accused persons named in the FIR within bracket, the present petitioners had an altercation with the with whom?
Hmm?
With the son of the
informant.
son of the first informant, and accused number 2, namely Sirazul Ali, also slapped the son of the first informant. And thereafter, the son of the first informant had consumed poison, and later on he was taken to the hospital where he died. Learned counsel for the petitioner submits that there is no allegation leveled against the petitioner number 3 in the FIR. Hence, at this stage, at least petitioner number 3 may be allowed to go on interim bail. On the other hand, learned additional public prosecutor submits that the result of the case diary will be decided and call for the case.
How did we fix?
2012.
Can it be?
2012. One is on bail, so 11/12,
1 and 2 are not
Eight.
paid.
8/12.
Fixing age. However, considering the fact that apparently no specific allegation has been made against the petitioner number 3, namely Manwara Khatun. What is the name? Manwara Khatun in the FIR, she is hereby directed to appear before the investigating officer of Deungmuk Police Station, case number 16/2023, within a period of 10 days from the date of this order. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with Deungmuk Police Station, case number 16/2023, she, within bracket, Manwara Khatun, shall be allowed to go on bail rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority, with a condition that condition number 1 is that it would not directly or indirectly, and number 2, you would cooperate in the let this case be listed again on 8th of December.
That's all right.
Item 11,
May please your lordship. For the 438 application, my lord, the FIR at page 9, my lord. What happened, my lord? Actually, there is a long standing, my lord, boundary dispute, my lord, regarding a plot of land, my lord, and dispute, my lord. And my lord, hence this case, my lord. At this stage, the allegations are there is no 326, my lord. 325 is there. So only I pray, my lord, it is our 5 and 6, my lord. 5 is a, 5 and 6 may be protected. 5 and 6, my lord. There is no specific allegation against anybody, my lord. All vague allegations, my lord. Everything will be clear from the case that
Why 5 and 6?
5, my lord, is a lady, my lord, the aged person, my lord.
Aged person.
And 6 is a lady, my wife, his wife, my lord. But there is no specific allegations against anybody. Vague allegations, my lord, and I categorically stated everything.
The case is registered under which?
But 307 is there, my lord.
34, common intention is there. In fact, Uzi, there are some allegations.
Who put the gamusa against?
They said simply the accused persons. And Uzi, there is, of course, he did something. Marjani Khatun had tried to take her in a bike by dragging her. Oh, and tried to take her. Okay. So allegation only against overt act against only accused number 1. Others, it's a statement that accused person did it. Section 34, there are materials because he was coming in an e-rickshaw and then everyone had gathered and then did the entire.
Okay, let us see the case.
Lot.
My lord, for 5 and 6, my lord.
Third, Mr. S.M. Abdullah P. that is counsel for also heard Miss S. Jahan, that is counsel for this application is the 438 of the Code of Criminal Procedure, 1973, has been filed by the 6 numbers of petitioners, namely right MP, who are apprehending their arrest in connection with Ajo PS case number 671/20. The list of accusation against the present petitioners is that on 16/11/2023, one Naushad Ali had lodged an FIR report the officer in charge of Ajo police station, inter area, alleging that on 16/11/2023 at about 4:20 p.m. when the first informant was coming towards his home in an e-rickshaw, the accused person intercepted the e-rickshaw and assaulted the first informant and also tried to put a gamusa within inverted gamusa around the neck of the first informant and dragged him towards the pond. However, he was somehow saved by one Baharu. It is also alleged in the FIR that the accused persons named in the FIR molested the female members of the family of the first informant and also set the house of the first informant on fire. And one of the FIR named accused, namely Uzir, also tried to molest the niece of the first informant. The counsel for the petitioner has submitted that why this happened?
Actually, paragraph 5, page 4, my lord. Actually, they are neighbors, my lord. And there's a long-standing land boundary dispute. My lord.
There was an altercation between the petitioners and the informant side on the issue of boundary dispute, which is long-standing in between them. It is also submitted by the counsel for the petitioners that the allegations leveled against the FIR are exaggerated and are not. It is further submitted by the learned counsel for the petitioner that petitioner number 6,
5 and 6.
petitioner number 5, Amjad Ali, aged person of 65 years old, and petitioner number 6,
Is a lady.
a lady of 50 years old, of age, 50 years of age, and they may be protected in case court wishes to peruse case. So, on the other hand, learned additional public prosecutor submits the perusal of the case that hence call for the case that think
11th of December?
11 December for case that. However, in the meanwhile, considering the age of petitioner number 5
Right.
and considering the fact that petitioner number 6, the lady of 50 years of age, they are hereby directed to appear before the investigating officer of Hajo PS case number 671/20 and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Hajo PS case number 671/20, they within bracket petitioner number 5 and 6 shall be allowed to go on interim bail of 30,000 each with one surety of likeness, subject to the satisfaction of their respective parties with following conditions. Number 1, they shall cooperate. Number 2, they shall not add.
Deeply obliged.
This case will be listed again on 11th of
Obliged.
12.
This is 438 application, Manoj. One of the allegation is that as per FIR, Manoj, both are, Manoj, young boy, Manoj, young boy and a young girl, Manoj. Girl is 21 years and boy is 28 years old, Manoj. He is constable in CRPF. As per allegation, Manoj, they got introduced in Facebook and thereafter, Manoj, they got introduced with each other and they started to talk with each other. Thereafter, they started to meet also, Manoj, and physical relation was also there. On 8/11, Manoj, the boy, girl and boy, Manoj, Lordship will find that page 13. 13 is the vernacular FIR. May I read the FIR, Manoj? সম্মানপূর্বক বিনীত নিবেদন is
No, what happened? Then they had relationship.
Yes, my lord. On 8/11,
Thereafter
my lord, the boy brought the girl, my lord. Both, my lord, went to Romania, my lord. They resided in a hotel, my lord. Thereafter, when the girl told him that her family member is coming, my lord, then he fled away from there. Because, my lord, family members of both the family were not agree to their relation. That is the only, my lord, reason. Lordship will find that page 13. Since May, my lord, they were in relation. No, 2021 they were in, my lord, Facebook. They got introduced in the 2021. In May they were in physical relation. May 23. Allegation of 376 may not be there because consensus, my lord.
Only that thing that the
Assault.
assault is,
That is 323
assaulted
and that
me.
is false allegation. Let
And
him, my lord, record his
420
statement.
420, of course, because he was supposed to take her to his home, but instead took her to the hotel and assault and the physical part.
No, there is no allegation that physical relationship was forceful.
No,
Yes.
forceful and all were not there. Only that he made a phone call, asked me to meet him. I told him he'll take me to his home and kept me in a hotel. That's 420,
Because
that cheating part.
because of the family member.
family dissenting.
But otherwise forceful thing is not there.
Let him record his statement, he is a government employee. CRPF constable.
Heard, heard Mr. N.K. Kolita, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure for 1970 has been filed by the petitioner Sanjeev Goro, who is apprehending his arrest in connection with Rongya Pierce case 607/23 under section 420/376/320 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 9/11/2023, the victim of, in this case, informant lodged an FIR before the officer in charge of Rongya Police Station, inter alia, alleging that she came to know about the present petitioner through Facebook in the year 2021, and thereafter they developed a romantic relationship between themselves. And it is alleged in the FIR that the petitioner proposed to marry the victim, and on believing that the proposal, on believing the offer given by the present petitioner, in the month of May this year, the victim accompanied the petitioner to a hotel and had physical relationship. Thereafter, it is alleged that in the month of May they had physical relationship. The FIR is lodged in November. Thereafter,
Again, on 8/11.
Uh.
Again on 8/11.
There are two incidents. In the May, the first one, where he had taken her to the first hotel.
thereafter again on 8th of November,
Yesterday again.
The-
9/11.
the petitioner took the victim girl to a hotel at Rangya on the pretext of taking her to his home and had physical relationship with her. And when the victim informed the petitioner that the family members of the victim are coming, it is alleged that the petitioner assaulted the victim and fled away from the hotel. So, learned counsel for the petitioner has submitted that though the case has been registered under section 376, also 376 of the Indian Penal Code also. However, there is no ingredient of the said offense in the FIR, as bare perusal of the FIR would reveal that the physical relationship between the victim and the petitioner was of consensual nature. So, learned counsel for the petitioner also submits that petitioner was in relation with the victim girl since long, and they had consensual physical relationship, and it is Why relationship sold? Why you assaulted?
No, my lord, assault, that is, my lord, false allegation.
Denied.
Yes, denied.
Learned counsel for the petitioner also has denied the allegation of assault as stated in the FIR and has submitted that. Where do you work?
My lord, CRPF, my lord, he is
That
now,
he is an employee of CRPF
and now posted at Madhya
and
Pradesh.
now posted at in
Madhya
Madhya
Pradesh.
Pradesh and is ready to cooperate in the investigation. On the other hand, learned additional prosecutor submits that perusal of the case diary would be required, hence call for the case diary fixing.
19th of December.
19 December for case diary. However, considering the submissions made by learned counsel for the petitioner and considering the fact that where perusal of the FIR does not suggest commission of offense under section 376 of the Indian Penal Code, the petitioner Sanjeev Boro is thereby directed to appear before the investigating officer of Rongya PS case number 607/2023 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Rongya PS case number 607/2023, the above named petitioner shall be allowed to go on bail of 30,000, shall be allowed to go on interim bail of 30,000, subject to the satisfaction of arrest authority with following conditions. Condition number 1, let this case be said again on 19th of
Obliged.
13,
May I please, Your Lordship? My lord, 438 application, my lord, allegation kindly filled at base 9, my lord. My lord, here, my lord, all the petitioners are family member, my lord, blood related. My lord.
Econ Processor. Econ Processor.
what is the allegation?
My lord, allegation under section 326, my lord, actually false, my lord. I am reading, my lord, FIR at page 9, my lord.
Who is injured?
My lord,
Who has been injured?
There are
injured, my lord,
Four.
here mentioned, my lord, 4 person, my lord.
Altapalli, 1, 2, 3, 4, 5.
My lord.
Let us peruse the case diary and injury report.
My lord, again, my lord, my humble prayer, my lord, kindly please at page 13, my lord. This is our allegation, my lord, our FIR, my lord. This was registered as allopathy case number 34. For allegation, my lord, against us, my lord, this is registered as allopathy case number 35, my lord. This is subsequent case, my lord. Actually, the accused person assaulted us, my lord. We are serious injured, my lord. We have been taking a treatment at Roman Hospital, Guwahati, my lord. My petition number 1, a retired person, my lord, is it about 68 years, my lord. He permanently resided at Guwahati, my lord. Till then, my lord, we may be protected, my lord.
It seems there was a mutual fight. Timing we will get in the format of the FIR. It's not here. Which one was lodged first?
Some of them may have inflicted injuries.
Both parties have got injuries.
Injuries. All are family member, my lord, blood related, my lord. Muzammil Haq is the nephew of accused number 1, my lord.
And overt act is not mentioned in
His father-in-law lodged FIR, my lord.
Yes, overtake is not.
not mentioned in the first FIR. I mean, FIR against him. They have not mentioned anything. In the second FIR, they have here also. I don't think so.
Abul Kalam Azad.
Above named accused
father-in-law of
persons. Above named accused persons. Overt act are not mentioned in respect of any.
What is the sir? Let them appear.
My lord, all are son of
Okay.
Rohiduddin, Bideshi Sheikh, Lekot, Nurul, my lord, all are related, my lord. My lord,
Let them
page
appear.
9, my lord.
No, good, let them appear.
Who has
My
been
lord,
injured?
till then, my lord, I may be protected, my lord.
Lordship,
My-
Who has been injured?
these 5 persons in respect of his against him FIR. Altaf Ali. So,
Relatives of the person.
perhaps Altaf in the second one and injured.
Altaf Ali, Moinuddin,
Tomser Ali is there.
Dilwar,
Moinuddin is also there.
Moinuddin.
Songsher,
Altaf, Moinuddin,
Songsher Naini. Well, maybe the names
Dilwar
are
Hussain.
written.
Or
Dilwar, no,
should
no.
we peruse the case diary?
My lord.
Let us see the injury reports if they are very serious.
Let us
My
peruse the
lord, till
case.
then, my lord, may be protected, my lord.
No, we don't know who has done what.
Who has done what? It's not reflected.
The injuries may be very serious also.
My lord, both are registered at same,
Injured persons are complainant.
all are family member, my lord. There is something happened, my lord.
No, let us
We admit,
peruse
my
the
lord.
case diary.
Short date, case diary, then your interim
My
will be
lord, at
considered.
least, my lord, petition number 1, my lord, tomorrow, my lord, Alabati, there is a, my lord, Delhi, there's meeting, my lord, he will be attend here. He's also a Haji, my lord. He's the main
No,
person.
what is the
Petition
ground?
number 1, Jalaluddin,
He's 68
retired
years.
person, my lord, he's a retired person. He was a railgar, my lord, the forest government. At least, my lord, petition number 1, my lord. My lord, here, my lord, allegation as per the direction of the wife of the accused number 1. Wife is not implicated here, my lord. This is very interesting, my lord. As per the direction of the accused number 1, all things are happened, my lord. But wife is not implicated here, my lord.
Heard Mr. R. Aditya, the counsel for the petition. This application under section 438 of the Code of Criminal Procedure has been filed by 11 numbers of petitioners, namely 1 to 11, and who are apprehending their arrest in connection with Alopati Sor Police Station case number 35/23 under section 120B/143/147/148/447/325/326/379 of the Indian Penal Code. The gist of accusation against the present petitioners is that on 5th of March 2020. So since March, you are not arrested.
My lord, one accused was arrested, my lord, recently, my lord, on 13. Bill alone.
On
Accused
5th
number,
of March 2023, one Abdul Kalam Azad
accused number
had
5.
lodged an FIR naming 16 numbers of accused persons in the state FIR, including the present petitioner and inter alia, alleging that on no dates are
Dates are also wrongly written, my lord, in the FIR.
In my copy, it is 5/7/23.
Yes, my lord, that is also in the original copy also, my lord. Their date was wrongly
how FIR can be lodged in
against us, my lord.
March for an incident which occurred in
My lord, my lord.
July.
It has to be
My lord, this is subsequent letter.
oh no, subsequent to Assamia copy code.
Page 12.
No, এখন FIR টা অসমীয়া এখন আছে এইখন No, this is 5-7 only.
আমার তো
that the petition, that the present petitioner have had trespassed into the house of the husband of the niece of the first informant and tried to forcefully take away 3 numbers of cow therefrom. And when the niece of the first informant resisted, he, along with other family members of the, were assaulted by the present petitioner, causing serious injuries over the person, on their person. It is also alleged in the FIR that an amount of rupees 2,30,000 was also taken away, was also stolen away by the present petitioner. The learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR is not true. It is further submitted by learned counsel that prior to lodging of the FIR by Abdul Kalam Azad against the present petitioner, the petitioner number 1, Jalaluddin, had lodged an FIR against the 16 numbers of accused, including the informant of the FIR against the present petitioner, before the officer in charge of Alupati Police Station, Alupati South Police Station. Interiorly alleging that there was an altercation between the parties on the question of not making payment for purchase of cows. And in that altercation, both parties had sustained injury. So, learned counsel for the learned additional public prosecutor submits that the
my full submission is para 7, my lord, 7.
learned additional public prosecutor submits that considering the nature of allegations level in the FIR, the perusal of the case diary would be necessary, hence call for the case diary. In the meanwhile, learned additional public prosecutor has submitted that considering the age of the petitioner number 1, only age or any other
My lord, may I kindly, my lord.
age of the
All
petitioner
are ladies,
number
my
1.
lord, they are also one, my lord, in the north, in Guwahati, my lord, global hospital. Doing duty as a north, global hospital, Guwahati, Hathigaon, my lord.
Who? Petitioner number 1. And considering the fact that petitioner number 10 and 11 are women, they may be allowed to go on interim bail till arrival of the case diary.
Yeah.
Stop. The prayer is allowed. Let the case diary be called for fixing.
11th of December.
My lord, another case fixing on 8 December.
Same case.
Yeah.
Same.
Same.
Other accused.
Fixing
Other case.
8th of December
8th
for
of-
case diary.
8-12.
In the
Gosh.
meanwhile, considering the age of the petitioner number 1, Jalaluddin Ali, and considering the fact that petitioner number 10, Sajida Khatun and Maleka Khatun are women, they are allowed to go on. they are directed to appear before the investigating officer of Allopathy or PS case number 35/2023 within a period of 10 days from the date of order and cooperate in the investigation, if they do so within the stipulated period of time, in the event of their arrest in connection with Allopathy or PS case number 35/23, they within bracket Jalaluddin Ali, Sajida Khatun and Malika Khatun are they shall be allowed to go on interim bail of rupees 30,000 each with one security of like amount subject to the satisfaction of arresting authority with the following conditions. One, let this case be listed again on 8th of December.
Obliged.
40,
Admission fees. Okay.
May I please your lordship, the second time bail application, my lord. Earlier it was rejected by this honorable court. My lord, there are 7 numbers of accused, my lord.
Is
FIR
there- is
case
there-
12, my.
CDU, this is a motion matter, doctor.
So,
So
is there would be required.
Appellate CD will be required.
Third, Mr. A.K. Azad, learned counsel for the petitioner. Also, Ms. S.H. Bora, learned additional public prosecutor. As this application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the present petitioner, namely Muhammad Mahroom Ali, for the second time, the perusal of the case diary would be necessary. Hence, call for an updated case diary.
On 15/12. doctor.
Let this case be listed again on 15th of December.
My lord, I mean, next week, my lord, if possible.
Let it be on lordship 11/12.
11th.
Obliged.
54 of the supplementary list.
Ma'am, this is a criminal Indian petitioner, my lord. Against the order passed by steam, my lord, principal of petitioner with a husband and wife with the respondent here, my lord. And 125 proceeding was initiated in them. And the Planet Family Court will granted. And our my lord, there is amount 7,000 to the wife and them. And I'm paying the same. In the meantime, my lord, she has filed another petition on for enhancement on 27. And that proceeding is going on yet not finalized, and that is the now evidence is placed. In the meantime, what happened, my lord, the respondent, my lord, have filed some documents, my lord, medical documents before the family court, my lord, and on that basis of which, my lord, the family court granted amount, my lord, to her. And again, which will have come, my lord. Actually, the medical certificate which is issued, my lord, and this is that is, my lord, kindly see annexure 3, page 19. Earlier granted maintenance I am paying, and in the meantime enhancement bill filed, that is also I am contesting. And probably that may be extended. And in the meantime, when application filed without any application bill, may read the improvement order.
Without any application means
Yes, kindly see that annexure 4, page 20. There you go. The opportunity has shown cause of his absence by petition number due to mistake of date, he could not appear today. On the basis of medical documents which were copied to the opposite party on the previous day, the opposite party is directed to deposit an amount of rupees 50,000 for medical treatment of the petitioner. Yes, applicant should be on 29/11/23, as the assessed medical cost of her proposed surgery has been modified at rupees 40,000. And being from Barbata, she will also need an escort with her at the hospital at Guwahati. A copy of order is sent to the WhatsApp of number for information of to the opposite party and for compliance immediately. Office to take it. So there is no application, only some medical papers has been submitted. And the medical certificate will kindly say who is issued and the annex 3 with my petition page 19. That was issued from the not by any doctor but
Now, on what ground you are challenging the impugn order? On what ground?
first of all, I am paying on maintenance allowance to her.
That this was passed on your back.
Other petition is pending for enhancement. That is why I am contesting that may be allowed for some time after some time. And in the meantime, she has filed this petition without any application, only some medical document. And one of the documents is kindly see annex 3, page 19. All yellow shares in it.
Any
And that is the disease which is mentioned here, that can be easily treated here, there in local hospital. There is a Fakhruddin Al hospital, medical college hospital in Bapata. But without going there directly has come to the Guwahati. And that too without any.
let us issue notice because no fixed date has been given for paying.
No, yes, 29 tomorrow. Tomorrow is given date. As you may read in middle. On the basis of the medical.
Tomorrow is not for the payment.
Yes, probably my reading may not be correct. I am reading that. On the basis of medical documents which were copied to the opposite party on the previous day, the opposite party is directed to deposit an amount of rupees 50,000 for medical treatment of the petitioner 12911. Probably tomorrow is the date.
Now, what is your prayer?
My brother, at this stage, it may be.
Mr.
It may be state.
A. Rashid, learned counsel for the petitioner, also heard learned counsel for the petitioner. Stop. This application under section 401/397 of the Code of Criminal Procedure has been filed by the petitioner Shafiqul Islam, impugning the order dated 16/11/2023 passed by learned Principal Judge Family Court Borpeta in FC within bracket CRL bracket close miss case number 571/2022, whereby the learned Principal Judge, Family Court Borpeta had directed the present petitioner to deposit an amount of rupees 50,000 for medical treatment of the opposite party on 29/11/2023. No, but this is required for her
Treatment.
treatment.
And treatment is there is a, so far my knowledge is deviated nasal septum with center and sinus problem in simple language. And that may be treated in at FAMM and medical college. But without that, case come directly to this hospital. It is not that that facility is not available at Borpeta. Anyway, so let it is a sinus problem.
No, but you were provided the medical documents on earlier occasion.
If there is given, but the only basis of that, some papers are given without application. That
No,
is
let
there,
her appear.
you know.
Let her appear.
Then in the meantime, if I am late again payment tomorrow, but that
you make prayer before,
but till her appearance it may be state below.
no. No state. What was the last line?
Now, if it is not statement, then it again it will be implemented on being executed.
We are fixing it shortly. You are knowing about this issue, medical urgency. On last date, you were informed by the,
Now that is informed. I am not. I am denying that I am not.
you
I
have
do not
not
know.
filed any objection to her prayer for.
But amount and the issuing officer who has issued the certificate, that is still not to be considered.
No, have you raised any objection before the?
No, I was on the last occasion, when it was told I was absent. There was some mistake of date, and I read first paragraph. The opposite party has shown cause of his absence by petition number so-and-so date, dated 29/23, stating that due to mistake of date, he could not appear today. That means that he was not present in the court on that day.
Issue notice to the learned counsel for the petitioner has submitted that the ailment which has been diagnosed, the ailment diagnosed, ailment suffered by the ailment which the respondent is suffering has been diagnosed as deviated nasal septum with sinusitis, which may be treated at local hospital at Barpeta at a much lesser cost. However, it appears that the petitioner has not filed any objection against the prayer for grant of 50,000 of grant of rupees 50,000 for medical treatment to the respondent by the petitioner. And counsel for the petitioner has also submitted that on the date when the impugn order was passed, that is on 16/11/2023, the 16/11/2023, the petitioner could not appear before the learned principal judge family court, and the impugn order was passed on his back without affording any opportunity to the present petitioner. Stop. Issue notice to the respondent and call for the scanned copy of the case record of which is the case record of FC criminal, is case number 57/2020. The petitioner shall take steps for issuance of notice on the respondent by registered post with ID. With ID returnable after 15 days. Returnable on, give it 18 Feb. considering the submissions made by learned counsel for the petitioner and considering the fact that on perusal of the impugn order, it appears that the impugn order was passed by learned principal judge, family court Barpeta, without affording any opportunity to the present petitioner to file any objection against the prayer of the respondent for payment of rupees 50,000 as prayed by her, the operation of impugn order is hereby stayed till the returnable date. Let this case be listed again on 18th. I'm taking 2 minutes break. Yeah, otherwise the court where the accused is produced would automatically grant bail.
Definitely, Lord.
On-
After passing of more than 90 days.
So
Let them appear with otherwise. It will be day after tomorrow.
or call after something.
Yes.
Mr. Vishwas is there.
My word.
Item 20,
Mail. The
Yes.
39 application lottery will find that page 60 is the particular affair. On the occasion of Lakshmi Puja, there are some altercation because the petition number who is a 60-year-old man, he runs a shop near the Bhavanipur Lakshmi Mandir. On the occasion of Lakshmi Puja, some bikers, they have parked in front of the shop, prevented him from running his shop. Some bikes were parked inside the residence premises. So there was some altercation. The petitioner, he informed the Puja committee. Puja committee accordingly informed the police. Police came and manhandled the petitioner and his family member. So the daughter of the family, petition number 1, he tried to videograph the entire incident. So on being influenced by the police, this affair was lost by the Puja committee. Already almost a month, 28 days behind the bar. Petitioner 1 is 60 years and petitioner number 2 is the son, 22 years.
Both are behind the bar
Since 1/11/2023, or almost 28 days,
for last 28 days.
8 days. Because, nothing such serious incident, because
Yes, consider.
My lord, there are material that my lord, they have assaulted my lord. Initially, my lord, the FNM, initially the informant and other person, lordship. Then when the police came, they also manhandled the police. Lord. That is there.
Otherwise, statements are recorded.
Statement recorded. Lord.
Their custodial detention may not be.
So there, I leave it to lordship because my lord.
Otherwise, materials are there.
Materials are there. Lordship. That my objection may be recorded.
Third, Mr. Z. Alam, learned counsel for the petitioner. Also, Mr. R.J. Burwa, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1915, has been filed by the petitioners, namely Godadhar Talukdar and Devananda Talukdar, who are detained behind the bars since 1/11/2023, within bracket for last 28 days, in connection with Atasar Kusi PS case number 403/2023. The gist of accusation against the present petitioners is that on 1/11/2023, one Babul Deka had lodged an FIR before the officer in charge of Bhavanipur Police Outpost, inter alia, alleging that the accused persons named in the FIR, including the present petitioner, had entered into altercation with some persons who had parked their motorcycle in front of the shop of the petitioner number one. And when police personnel tried to intervene in the said altercation, the present petitioner assaulted the police personnel also, and also outraged the modesty of woman home guard Asiran Nisa by pushing her on the road. Is it true? What is it?
There was an altercation, no such serious injury or has taken place.
Learned-
Because they
learned-
tried to videograph the daughter and police tried to take away the mobile.
Learned counsel for the petitioner submits that the allegations made in the FIR against the present petitioners are not true. In fact, there was an altercation in between the petitioners and the persons who had parked the motorcycle and who have misbehaved with the daughter of the petitioner number one. And when the daughter of the petitioner number one started to videograph the incident, some of the police personnel tried to snatch away the mobile phone, which resulted into altercation. However, nothing as alleged in the FIR had happened. On the other hand, learned additional public prosecutor has produced the case diary of Patasar Kusi PS case number 403/2023 and has submitted that the investigating officer has recorded the statement of witnesses under section 161 of the CRPC, and on perusal of the said statement, it appears that there are incriminating material against present petitioners. So I have considered the submissions made by learned counsel for both the sides and perused the material available on record, including the case diary of Patasar to PS case number 403/23. Though it appears that some of the witnesses whose statements are recorded by the investigating officer under section 161 CRPC have implicated the present petitioner. However, considering the fact that the petitioners have already been detained behind the bar for last 28 days, and also considering the progress made in the investigation, their further custodial detention does not appear to be necessary for fair completion of the investigation of Patasar Kusi PS case number 403/23. So in view of above, the accused persons, the petitioners, namely Gadadhar Talukdar and Devananda Talukdar, are hereby allowed to go on bail of rupees 30,000 each, with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Bojali, with following condition that they shall cooperate in the investigation. Number two, they shall not direct with above observation.
Deeply aware. Deep.
Typing 90.
May please alert. For such an application,
You have already completed
complete the statutory government. 92 statutory.
out Mr.
Okay.
F.A. Hassan, learned counsel for the petitioner. Also heard Mr. R.J. learned additional professor, who has produced the case diary of Boko PS case number 397/2023. It is submitted by learned additional public prosecutor that the present petitioner was arrested on 29/8/2023 and has been detained behind the bar since last
91 days.
91 days. Now it is submitted by learned counsel for the petitioner instead of additional 91 days. On the other hand, learned additional public prosecutor has submitted that the maximum period of detention which may be authorized for the offences involved in this case under section 167 clause 2 is 90 days, which has already been completed. Hence, no further detention can be authorized from the present petitioner. In view of above, in view of fact that the petitioner has already completed the statutory period of detention, he is, hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned JM Judicial Magistrate First Class, Boko, with following conditions. He shall not directly or indirectly make any use of it. With above observation, this bail application has been sent back again. Only one condition.
21.
May please your lordship. Lordship 439 daily application lordship. Today is 32 days behind the bar lordship. 32 days lordship. Allegation mainly 326 and 379 lordship. 326 and 379.
326. What is the
My lord, the injury report is, my lord, previous lordship, caused by sharp weapon. My lord, only, my lord, question is that, my lord, who has assaulted, that is not specific lordship. Whether it is accused person has assaulted or, my lord, somebody else. Because there are around 3 to 4 accused person in the FIR, 6 accused person in the FIR. Here is the accused number 2 lord.
against him materials are there?
Against all the accused person, lordship, they said they have assaulted lordship, and the injury report suggests that it is a, my lord, grievous injury caused by sharp weapon. Lord. But who has inflicted the injury, that is not specific from the case.
Where the injury has,
My lord, that is my lord, right maxillary region, my lord, that is the
what is your submission?
my submission, lordship,
He has been behind the bar
for last
for
32
days.
32 days, lordship, and his statement recorded, lordship, but some of the accused person are yet to be arrested. As
Let-
far as this
Let him appear.
no, he is
No,
not,
even
yeah.
after bail, let him appear
Fine.
every week.
Fine.
So as
They are family member lordship. Family member.
heard Mr. Rashidul, heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Aminul Islam, who has been detained behind the bar since 27/10/2023 in connection with Mankasar PS case number 16/2021. Stop. The accusation against the present petitioner is that on on 5/1/2000, when the affair was lodged,
Lordship.
21.
21 lordship. Before 2 years earlier.
were you arrested?
2023, 27, 10, 23. After 2 years.
After 2 years.
Lordship.
The on 5/1/2021, one Koriful BB had lodged an FIR before the Mankasar officer in charge of Mankasar police station, inter alia, alleging that the accused persons named in the FIR, within bracket 6 numbers of accused persons are named in the FIR, bracket close, comma, including the present petitioner, had assaulted the son of the first informant with a knife and bamboo stick. Sons of the first informant with a knife and bamboo stick, and had caused injury on their person. Stop. What is your submission?
Lordship, kindly peruse the page number 4, Lordship, para number 6. May I read, Lordship? Actual page, Lordship. It is a false FIR, Lordship. May I read?
Learned counsel for the petitioner had submitted that the petitioner, that the allegations leveled against the present petitioner in the FIR are not true. And same has been lodged due to the existing boundary dispute between the first informant and between the family members of the first informant and the present petitioner since long back. On the other hand, learned additional public prosecutor has produced the case diary of the Mankasar PS case number 16/21, which was called for in connection with it, and has submitted that from the injury report which is available in the case diary, it appears that the victim sustained grievous injury which is caused by sharp weapon. However, from the statement of the witnesses recorded under section 161,
And secondly, my lord,
Yeah,
the
please.
victim statement is not in the case diary, Lordship.
it is not, it cannot be ascertained as to who had caused the injuries on the victim. It is further submitted that the statement of the victim under section 161 CRPC is not available in the case diary. However, the statement of the present petitioner has already been recorded by the investigator. The other co-accused are yet to be arrested.
Yes, my lord.
Learned additional public prosecutor opposes the grant of bail to the present petitioner on the ground that some of the co-accused are yet to be co-accused named in the FIR are yet to be arrested. Stop. I have considered the submissions made by the counsel for both and have gone through the materials available in the materials available on record, including the case diary of Mankasar PS case number 16/2021. It appears from record that the incident alleged in the FIR had occurred 2 years ago, that is in the year 2021, and the present petitioner was arrested only on 27/10/2020. It also appears that he has been detained behind the bar for last 32 days, and his statement has already been recorded. Further, considering the progress made in the investigation, his further custodial detention does not appear to be necessary if he otherwise cooperates in the investigation. In view of above, the petitioner Aminul Islam, alias Aminur Islam, is hereby directed to appear before the, hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of Chief Judicial Magistrate South Salwara, Mankasar, with following condition. The petitioner shall appear before the investigating officer of Mankasar PS case number 16/21 every week for next 3 weeks or till the investigation is completed, whichever is earlier. The petitioner shall not directly or indirectly make any inducement letter from. With above observation, this bail application is thereby disposed of. When
Bless you.
22,
May I proceed? Lordship? For 39 application, my lord, 47 days in custody, my lord. And my lord, FIR may be seen at page 9. Injury report along with case diary along with injury report was called for. Page 9 is the FIR.
Yes.
My lord, we have received the case diary, Lordship. My lord, two persons sustained injury, Lordship. One is Anjali Mandal and another is Radhakanta Mandal, Lordship. As far as my lord Anjali Mandal is concerned, Lordship, there is no such injury, Lordship, only some abrasion part, Lordship. And Radhakanta Mandal, his my lord, injury report is not yet received, Lordship. An allegation is that, my lord, the accused person, my lord, they have assaulted the Radhakanta Mandal and my lord, both the hands has been fractured, Lordship. That injury report is not before us, not in the case diary.
My lord, 47 days in custody. And my
But
lord,
but they are behind the bar for since last.
My lord, that I have also gone through.
Why injury report is not collected?
My lord, that has not been able to collect by the as per the note of the investigating officer, Lordship.
Otherwise, statement of witnesses.
Statement of witnesses are recorded, Lordship. There are already materials against this person, Lordship.
Okay.
land district. M. Ali.
Heard Mr. M. Ali, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mohar Ali, who has been detained behind the bar since 12/10/2023 in connection with Abhayapuri PS case number 468/23 under section 326/354B/34 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 12/10/2023, one Srimati Anjali Mandal had lodged an FIR before the officer in charge of Abhayapuri police station, inter alia, alleging that the accused persons named in the FIR, within bracket, 3 numbers of accused persons are named in the FIR. Bracket close, including the present petitioner. On 12/10/2023, at 6:45 AM in the morning, started quarreling with the first informant over regarding a matter regarding boundary of the land, and assaulted the family members of the first informant, causing serious injuries on their person. It is also alleged in the FIR that the the first informant Anjali Mandal and Radhakanta Mandal had to take treatment in the hospital for the injury sustained by them. Learned counsel for the petitioner has submitted that the allegation leveled against the present petitioner in the FIR is not true. Allegations are not true. And there was an altercation between the first informant and the petitioner's family over a boundary dispute between them. However, nothing as alleged in the FIR had occurred on the fateful day. On the other hand, learned additional public prosecutor has produced the case diary of Abhayapuri PS case number 468/2023 and has submitted that the injury report of the first informant Anjali Mandal is available in the case diary, and from the said injury report it appears that she sustained only abrasion and no serious injuries were caused to her. On the other hand, it is further submitted that the injury report of Radhakanta Mandal is not available in the case diary. However, it is submitted by learned counsel for the learned additional public prosecutor that in the meanwhile, the investigating officer has recorded the statement of relevant witnesses, including the accused persons. And the investigation has fairly progressed. Stop. I have considered the submissions made by learned counsel for both sides and have perused the material available on record, including the case diary which was called for in connection. Considering the fact that investigation of this case has fairly progressed, and also considering the fact that the petitioner has already been detained behind the bar since last 47 days, behind the bar for last 47 days, for last 47 days, this court is of considered opinion that further custodial detention of the present petitioner may not be necessary for fair completion of the investigation of the case. Hence, the petitioner Mohar Ali is hereby allowed to go on bail of rupees 30,000 with one security of life amount subject to the satisfaction of
SDJM?
Subdivisional Judicial Magistrate within bracket M Abhayapuri with following condition. Condition number 1 and 2. With above observation, this bail application is hereby disposed of. Send back the case.
Obliged. Hello.
23,
Look, 23, we have not received the case diary.
Your Honor, kindly pass about the matter for the time being for the case that if not arrived.
When can you
I'm in touch with the concerned police station. It's coming. No.
you are smarter than additional public prosecutor.
My lord, let it be day after tomorrow, Lord.
Heard, Mr.
Because we have
What
to
is
go
your
to the
name?
case diary, Lord.
What is your name?
B Cardon.
Heard Mr. P. Cardon, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived, and prays for some more time for producing it. If there is allowed, let this matter be listed again on.
30 or 30,
Four.
4 months. Today is 33 days. Lord.
Okay, 30/11. Let this case be listed again on 30/11 for case.
নিশ্চয়
Twenty-four,
আইলাম চাব লাগিব ন নিশ্চয় কেনে
May please, Your Lordship. 439 Your Lordship. It was called for my lord.
কেজারি নট রিসিভ
P6A, my lord, Jahal already, Singhal already recovered, my lord.
26 days, Lordship.
26 my lord, today.
But perusal of the case diary would be necessary. Heard Mr.
Yeah.
A.K. Azad.
Lord.
A.K. Azad, the counsel for the petition, also heard Mr. R.J. Barua, the petitioner for the prosecutor, who prays for allowing some more time for producing case diary. Prayer is allowed.
8/12
Let this case be listed again
the
on
4/12
4th of December for case diary.
Always.
26,
May I please, Your Lordship? My lord, 438 application, my lord. FIR case 8, my lord. Basically, this is a case of 498A, my lord. The marriage was solemnized about 3 years back, 3.5 years back. And I have a child of 2.5 years. She left my home and now living in her parents' home. I went to my wife's house to meet my child, my lord. And she obstructed me not to come into her house, and some altercation was there. And this case has been filed after thought under section 326 and 307. Nothing was happened about section 307 and 30.
Since how many days you are behind?
My lord, I was arrested, my lord, on
43 days.
43 days. Present today.
My lord, injury report is not clear, Lord. My lord, there are two cut marks, Lord. One is in the, my lord, left hand, and another is in the, my lord, left shoulder, Lord. My lord, but Lord, doctor has advised him to, my lord, to do some X-ray, Lord. That is what is not clear from the my injury report whether it is a grievous or simple, my lord.
My lord, this injury she made herself, my lord, actually. She made herself by her own finger, my lord.
But according to my lord, he has given statement, my lord, investigating officer, Lord, that my lord, he asked the wife to come back to his house, Lord, but he refused, Lord. And my lord, father-in-law and mother-in-law of the accused also, my lord, refused to send her back to her husband's house, Lord. That is why, my lord, he is assaulted. That is, he also stated in his statement. On the injury report is not clear, Lord, whether it will come to under 326 or not.
Where is the injury? In which part of?
My lord, left hand and left shoulder.
And how the injury has been caused?
That is also weapon.
No,
Also,
from the statement of the victim.
yeah.
Knife or?
No, with dowel, Lord.
Okay.
Dowel.
My lord, allegation is that I went with a dao, my lord, but nothing like this, my lord. I want to convince her to take her back and to meet my child.
If you are released, you will again threaten your wife.
So, my lord, after I have tried my level best, but now I failed, so I must leave. Otherwise, I tried for the sake of my child.
What is your topic?
Otherwise, Lordship, involving because of the injury report, Lordship, which has come to my lord.
Otherwise,
Yes, Lordship, then my lord. Other investigation already by the progress, Lordship, because statement of the witness are recorded. Even Lordship, they have also implicated the accused person, Lordship.
okay. Heard,
So
Mr.
there are sufficient materials
Heard,
collected
Mr.
by against him.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mohammed Mozammil Haq, who has been detained behind the bar since 17/10/2023 within bracket for last 43 days in connection with Bahata Sareli PS case number 325/23 under section 498A/447/326/307 of the Indian Penal Code. the gist of accusation against the present petitioner is that on 16/10/2023, one Amanisha Begum, who is the wife of the present petitioner, had lodged an FIR before the officer in charge of Vayata Sarili police station, inter alia, alleging that after her marriage with the present petitioner, she has been subjected to cruelty by the petitioner and unable to tolerate the inhuman torture of the present petitioner. The informant left her matrimonial home and is now staying with her parents at Malibari. It is alleged in the FIR that on 15/10/2023, at about 10:30 p.m., the petitioner came to the maternal home of the first informant armed with a dao and had assaulted the first informant, causing injuries on her person. Learned counsel for the petitioner has submitted that the dispute between the petitioner and the first informant is of matrimonial nature. In fact, the informant has, after birth of their child, who is now 2.5 years of age, left the matrimonial home along with her child. And on the date of alleged incident, the petitioner went to see her child in the matrimonial home of the first informant, who prevented the petitioner from meeting his child, and on this some altercation occurred. However, it is submitted that nothing as alleged in the FIR had happened. On the other hand, learned additional public prosecutor has produced the case diary of Vayata Charili PS case number 325/20, and has submitted that though from the injury report is there,
It is there.
from the injury report available in the case diary, it appears that the first informant sustained 2 injuries, one over her arm,
Left hand
left hand,
and left shoulder.
and another over her left shoulder, which is caused by sharp weapon,
That is not mentioned in the my lord injury.
cut injury. However, the nature of injuries, however, the opinion regarding the nature of injuries caused, sustained, and the weapon used for causing injury has not been stated in the said report. And thus, from the materials on record, it cannot be said as to whether the first informant sustained grievous injury caused by sharp weapon or not. Stop. However, learned additional public prosecutor has also submitted that in the meanwhile, the investigation has fairly progressed, and statement of victim as well as other witnesses have been recorded by investigating officer who have implicated the present petitioner in this case. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. Considering the progress progress made in the investigation, as well as considering the fact that the petitioner has already been detained behind the bar for last 48 days,
No, 43 days.
43 days, comma, his further custodial detention does not appear to be necessary for the sake of fair completion of the investigation of Vayata Charali case number 325/23. In view of above, the petitioner Mohammad Mozammil Haq is thereby allowed to go on bail of with 30,000 with 150 of like subject to the satisfaction of learned SDJM Rongia, SDJM Rongia, with following condition. Condition number 1, with above observation, this bail application is made by the court of the same
Published.
condition.
28,
FIR page number 8, my lord. We are on interim, my lord.
You are on interim.
My lord. And the FIR is on, my lord.
It is under section 302. Who died?
My lord, the informant's husband, my lord.
How?
My lord, so far my instruction is concerned, my lord, due to the family dispute of informant and husband, my lord, he committed suicide. My lord.
Suicide by hanging.
No, my lord, that is the allegation also, but my lord, postmortem report says also it is a my lord, homicidal in nature also. There is strangulation mark in the neck also.
Oh.
There are some circumstances, and my lord, these are the accused person also who called him out from the house, and later in the morning also, his dead body was found, my lord,
Dead body was found hanging.
hanging lord, in a tree. Now, lordship, this is a case of 2011, lordship. Now, lordship, this accused person, they were granted interim protection by this honorable court on 22/5/2023, and pursuant to that, lordship, accused number 2 appeared, lordship, and accused number 1, lordship, is reported to have been died, lordship. Accused number 1. Accused number 2 appeared, lordship, and he has been granted bail, lordship. But there are material that, lordship, they were the person, lordship, who called him out from the house.
But this is a very old case.
Old case, lordship, my lord. So let them, my lord, let the one, only one person he died, lordship. So let him appear, lordship, so that my investigation can be completed at an artist level.
Mr. F.A. Luscott, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the petitioners has submitted that by order dated 22/5/23, the petitioners, namely Mainul Haq Luscott and Moibur Rahman Luscott, were allowed to go on interim anticipatory bail by this court with certain conditions. And in pursuant to the directions of this court, the petitioner who appeared,
Both are appeared. my lord,
Petitioner,
but-
no, petitioner number 2 appeared, lordship. He is appeared, but because I have found him, his bail bond, lordship, in the case that
petitioner number 2, Moibur Rahman Luscott, appeared before an additional public prosecutor, and Moinul Haq Luscott has in the meanwhile
my lord, report is, my lord, date of report is 26/5/2023.
has expired
So, पता तो मुझे।
on 26/5/2020. Learned additional public prosecutor has produced the case diary of Silchar PS case number 1651/2011 and has submitted that this is an old pending case of year 2011, and after grant of interim anticipatory bail to the petitioners, petitioner number 2, Moibur Rahman Luscott, appeared before the investigating officer and his statement was also recorded. In the meanwhile, the petitioner number 1, Moinul Haq Luscott, has already expired. So considering the fact that the petitioner number 2 has Now petitioner number 1 has already expired. The prayer for anticipatory bail of the said petitioner has become infructuous. As regards petitioner number 2, Mohibur Rahman Laskar, it appears that he has complied with the directions of this court and has cooperated in the investigation with the investigating officer. Hence, the interim anticipatory bail granted to the petitioner Mohibur Rahman Laskar by order dated 22/5/23 is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this bail application, anticipatory bail application.
Obliged.
29,
It's your popcorn.
29, we have not received the case diary.
May I please, Lord? My lord, the petitioner was in interim bail, my lord. By order dated 14/6/2023 was
14,
14/6/2023. Interim was
when can you
granted.
produce the case? Heard Mr. K. U. Ahmed, learned counsel for the petitioner, also heard Mr. R. J. Barua, learned additional public prosecutor, who prays for another date for producing the case that the prayer is allowed.
11/12.
Let this case be listed again on 11th of December. The interim order shall continue.
Obliged.
31,
May please, your lordship. Lordship, 439 bail application. Lordship, earlier several times CD was called for. Perhaps today it is
38.
38.
31 case diary not received.
Lordship, we are on interim, Lordship. Actually, Lordship, in the case, main accused has been already arrested and he is subsequently released on bail, Lordship. We are parents, father and mother, Lordship. 360 victim is already recovered, Lordship.
Have you appeared?
Lordship, your Lordship order, Lordship. May
When have you appeared?
Lordship, 28/6, interim order was passed and subsequently after getting the certificate copy, we have appeared and reported our.
What is the offense? 360.
366.
Whether victim has been recovered
Recovered, Lordship. Your order is there, Lordship. We kindly pay
or for the main
main accused. We are parents,
we
Lordship.
can dispose it off.
Lordship.
In the case diary not
You
received.
go through that order. Or
After perusal of case diary, this order was passed. Your Honor.
if main accused,
Already released.
who has been released? Who is the main accused?
Naizuddin.
Who is Naizuddin? What is your relationship?
Good.
Anisha and Nazmut. How they are
Naizuddin parents, Lordship.
parents?
Parents.
Oh, these are mother and father.
Mother.
They have
My lord, this person was granted bail, lordship, pursuant to the length of detention, lordship, and on the basis of his submission, that victim got recovered.
Lordship, we are parents, Lordship. There is
no on several occasions
Yes, my lord, that I have also seen.
heard Mr. R.
Islam.
Islam, learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not yet been received and prays for another date for producing the same. However, it appears from record that on several occasions, the prosecution side has been granted indulgence and in spite of repeated chances given to the prosecution side, it has failed to produce the case. On the other hand, it appears that by order dated 28/6/2023, both the petitioners were allowed to go on interim anticipatory bail by this court. And it is submitted by learned counsel for the petitioners that in pursuant to the directions of this court, both the petitioners have appeared before the investigating officer and have cooperated in the investigation. It is further submitted by learned counsel for the main accused in the case, namely
Nizuddin Sheikh
Nizuddin Sheikh, has already been granted bail by this court
on 87.
on
18/7.
on 18/7/2023 after perusal of the case diary, considering the length of detention undergone by the said accused. Considering the fact that main accused of this case has been arrested and has already been released on bail, and also considering the fact that the present petitioners, who are parents of the main accused, have cooperated in the investigation, their custodial detention does not appear to be necessary for fair completion of the investigation of this PS case number 637/23. Hence, the interim bail granted to the present above named petitioner by order dated 28/6/2023 is hereby made absolute, with condition number 2 and 3 attached to the said order remaining intact. With above observation, this anticipatory bail application is thereby disposed of.
Obliged, Lordship.
32,
No, 32 searches submitted, Lord.
You are on interim.
Interim Lordship, by
You-
order 22/8/23 Lordship.
You appear.
Appeared Lordship.
Heard Ms. G. Bora, learned counsel for the petitioner. Also heard Mr. R. J. Purva, learned petitioner public prosecutor, who has submitted that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
177/2023, dated 31/8/2023.
On the other hand, learned counsel for the petitioner has submitted that by order dated 22/8/2023, the petitioner was allowed to go on interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated with the investigation. Stop. Considering the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the above named to the petitioner, namely Parval Saikia, is hereby made absolute, with condition number 2 and 3 attached to the said order remaining intact. With above observation, anticipatory bail application is hereby.
33,
What is to be done?
We have also not received the case diary. The matter come again.
None appears for the petitioner on call. Let this matter be listed again on 30 1/5,
My lord,
1st of December.
my lord.
34,
May please, your Lordship. Lordship, 438 bail application.
Case diary not received, Lord.
I am on interim, Lordship. Several time honorable court would call for cancer.
When you got the interim,
Interim on 12/9/2023. 23, Lord.
Not several times. This is the
This is the third time.
Third time, Lord.
heard Mr.
Yes,
K H Soikia, learned counsel for the petitioner. Also heard Mr. R J Barua, learned additional public prosecutor, who prays for another date for producing the case diary. Prayer is allowed. Let this case be listed again on
12.
12/12. The interim order shall continue. till next.
Obliged, Your Lordship.
35,
My lord, 35, Lordship, we have received the case diary, Lordship, my lord, along with the bail objection of the my lord investigating officer. However, Lordship, the statement of the accused person is not recorded, my lord, not available in the with the case diary, Lordship. He is on interim, Lordship.
Yes, appeared matter against, well,
No, he has appeared, Lordship. That my lord endorsement is there, Lordship, but the statement is not there, Lordship. That is my lord important, Lordship.
Statement has not been recorded.
My lord, that is recorded or not, my lord. Whether
But
it
he
was
has
recorded.
appeared.
He has appeared, Lordship.
2 times he has appeared.
So we will call for the update case diary, my lord, along with his statement.
No, recording of the statement is the prerogative of the IO.
IO, my lord.
IO may record, may not record.
But whatever he has stated, Lordship, that is important. Because Lordship, a guard, my lord, a minor guard, he committed suicide. I don't know. He committed suicide, Lordship. And she was found, my lord, 4 months pregnant, Lordship.
You are on interim.
Yes, Lord.
So what is your submission? Let the statement be recorded.
My lord, he has appeared, Lordship. If the IO has not recorded his statement, Lordship, that is my lord, different aspect of the matter. But if it is recorded and it is not in the case diary, Lordship, that is what I like to submit.
Okay. Now, what should we do? We should wait for
My lord, since the
updated
case
case.
diary is, my lord, available with us, we'll send back the case diary, Lordship. Taking a sorted, Lordship, so that, my lord, case diary can be, my lord, obtained again.
And whether he has to appear again. He can appear because
Yes, he can appear, Lordship, if necessary, my lord.
For the last provision, my lord, the honorable court granted interim bail perusing the case diary and case diary has been detailed. And on the condition and directed to the petitioner to for DNA test and petitioner is ready to for DNA test. If he
for DNA sampling. Let him cooperate. Because he has appeared.
He has appeared, Lordship.
Whether statement is recorded or not, that is the IO's concern.
Man.
He should cooperate with the investigation.
Lordship. That may be reflected,
If,
my lord.
if DNA sampling is required, he should cooperate in that also.
My lord.
Heard Mr. S. Rahman, learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor. Learned additional public prosecutor has produced the case diary of Behali Police Station case number 101/2023, which was called for in connection with this case, and has submitted that though on perusal of the case diary, it appears that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer. However, his statements under Section 161 PRPC are not available in the case diary. It is also submitted by learned counsel for the petitioner that nature of offense involved in this case may require DNA sampling of the present petitioner done, for which his cooperation would be required. On the other hand, learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 16/10/2023, and he is ready to render all cooperation, including DNA sampling, if necessary, for the sake of fair investigation. Considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, the interim anticipated bail granted to the present petitioner, namely Anand Kumar Soni, alias Anant Kumar Soni, is hereby made absolute with following conditions: that the above named petitioner shall appear before the investigating officer as and when so required for the sake of completion of the fair investigation of the Behali PS case number 101/23. Number 2, the petitioner shall also render all necessary assistance to the investigating officer if he deems it necessary to do the DNA sampling of the present petitioner for the sake of fair investigation. The petitioner shall not directly or indirectly make it in this threat or promise. With above observation, this anticipated application thereby.
My lord,
Anything-
petitioner may be directed to appear, my lord, along with this copy of this order, my lord, within 15 days. Because that has been mentioned regarding DNA.
The petitioner is directed to appear before the investigating officer again within 15 days of the date of this order with a certified copy of this order to be produced for the investigating officer.
Mark.
With above observation, this anticipated.
Please change the FIR.
What is your name, the present petitioner?
Abdul Hamid, Lordship, petitioner number, accused number 1.
Yes, what is the purpose?
There is love affair between them for past 6 years. And the petitioner is also willing to marry her. It is also reflected in the affair. But due to interference of the family members, some dispute took place. And in this regard, the informant is apprehending that he will not marry the family member. As a result, the informant filed the other accused are granted bail. Both are aged about 28 years. For last 6 years, they are making the. And here is
Lordship,
also
164 statement, he has initially admitted that there is a love affairs between them. Not out of that, Lordship. He has forcefully made physical relationship with him. And in the FIR also, and the 164 statement also it reveals that she herself came out to the house of the petitioner at her own sweet rate.
He has to accompany.
Yes. And see the measure.
let him appear.
Lordship.
Heard Mr.
Yes.
S.
Along
Along, learned counsel for the petitioner, also heard Ms. S. H. Vora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure for 1973 has been filed by the petitioner, namely Abdul Hamid, who is apprehending his arrest in connection with Olgosia PS case number 157/2023 under section 417/376/341/356/506/34 of the gist of accusation in this case that on 1st of November, the victim slash informant of this case had lodged an FIR naming 7 numbers of accused persons in the FIR, including the present petitioner, inter alia alleging that the petitioner and the victim were in a romantic relationship, were having love affair since 2017, and it is also alleged that though the present petitioner wants to marry the first informant, however, other accused persons named in the FIR, who are the family members of the present petitioner, are opposed to any such relationship. And they do not agree the continuation of relationship between the first informant and it is also alleged in the FIR that the on 26/10/2023 accused that the present petitioner had asked the informant to come out of her home along with the money, and thereafter he accompanied the present petitioner and stayed with him in a room for a night where they had physical relationship. Thereafter, she accompanied the. Thereafter, it is also alleged that the informant accompanied the present petitioner to his house along with him. However, the other accused persons named in the FIR, that is, the family members of the present petitioner, restrained the informant and assaulted her, causing injury over her person. Learned counsel for the petitioner has submitted that the victim as well as the petitioner are both are major and having love affair since last 6 years. It is further submitted that the petitioner is ready to marry the informant, and it is only his family members who are opposed to such a relationship. Further, it is submitted by learned counsel for the petitioner that their reading of the FIR would reveal that the relationship between the first informant and the present petitioner is consensual in nature. On the other hand, learned additional public prosecutor before learned counsel for the petitioner has also submitted that the other co-accused persons are already enlarged on bail. By which court?
by order dated 10/11/2023, passed in AB number.
By this court.
Which court?
By this.
High Court.
Yes.
by this court. And the petitioner is also ready to cooperate with the investigation. On the other hand, the petitioner prosecutor has produced the case diary of Kolgosia case number 157/20 and has submitted that from the materials available in the case diary, it appears that the petitioner and the victim were having a love affair with long, and the victim herself accompanied the petitioner on the date of alleged offense, and both are major.
No.
Considering the submission made by the counsel for both the sides, as well as materials available on record, including the case diary of Kolgosia case number 157/20, as well as considering the fact that the other co-accused persons are already on bail and the perusal of FIR prima facie reveals that prima facie indicate that the relationship between the petitioner and the victim was of consensual nature, the petitioner, namely Abdul Hamid, thereby directed to appear before the investigating officer of Kolgosia case 157/20 within a period of 10 days from date of the order and cooperate in the stop. If he does so within a stipulated period of time, the event of his arrest in connection with Kolgosia case number 157/20, he shall be allowed to go on bail of 30,170 of life subject to the satisfaction of the arresting authority with with above observation that is the prepared application is thereby disclosed.
It can be 4th January or 4th January.
Yes. In Kohima matter, next date, 4th January.
4th January. If otherwise, the correct first day, what?
Item 47.
438 of the bail application. Allegation under 366 IPC. Chemistry phase 3, para 3, last break. Copy of the certificate dated 13/10/23, which was issued by the medical and health officer. The alleged victim was 18 years of age at the time. Alleged offense as her date of birth was 22/10/2005, and the date of birth of the petition is 24/1990.
What is the age?
18 years, Lordship. And the Lordship, the petitioner and the victim girl is relationship for last 2 years.
Only, my only contention is this, the victim is yet to be recovered.
Okay. Where is the victim?
But victim already his house.
In the petitioner's house.
Already covered.
But 164 statement I have not found, and in the IU's note also, it's clearly stated the victim is yet to be recovered. So let it be just after some time, after some days, Lordship, because her statement is required under 164.
Then till then, let him be on interim.
Lordship,
Otherwise, he will be running.
yes.
Him already reported.
No, there is no such endorsement in the case
Yes, in the
diary.
case diary.
And your submission is that the victim herself eloped with you.
Victim already in his own home.
No, but she went along with you on her own. Thereafter, she came back to home. Is that your submission? Heard Miss
He
T. Rajkar, learned counsel for the petitioner, Also heard Miss S. H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Joynal Haq, who is apprehending his arrest in connection with Behali PS case number 141/2023 under section 366 of the Indian Penal Code. The accusation against the present petitioner is that on 7/10/2023, one Muhammad Amir Hussain had lodged an FIR before the officer in charge of Behali Police Station, inter alia, alleging that his daughter, aged about 17 years, has been missing, 17 years, went missing from her house on 4th of this October 2023 at about 9 p.m. And later on, he came to know from some sources that the daughter of the victim, daughter of the first informant, is with the present petitioner. Learned counsel for the petitioner has submitted that the victim girl is a major and is a girl of 18 years of age and has attained majority, and her date of birth is 27/10/2005. And in support of this submission of learned counsel for the petitioner, he has annexed a copy of the date of birth certificate of the victim as Annexure B. It is further submitted that the victim and the present petitioner were in relationship since last 2 years, and on 4th of October, the victim herself eloped with the present petitioner. Where is she now, victim? I will record it in the order. If later on from the case there is if her statement something else is found, then your petition, then your interim would be rejected. Where is victim now?
Him already, his phone.
Her
Already,
own-
his phone.
The learned counsel for the petitioner has submitted that in the meanwhile, the victim has returned back to her own home, and the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of the Behali PS case number 141/2023 and has submitted that from the case diary, there is no endorsement to indicate that as to whether the victim has been recovered or not. And she prays for some more time for seeking necessary instructions from the investigating officer as to whether the victim has been recovered or not. The prayer is allowed. You will send back the case diary. The prayer is allowed. Let the case diary be sent back to be called again after updation on which date?
Lordship, let it be on 15th.
On 15th of December 2020.
Lordship, short date, time short date.
No, I am giving interim to you. I'm giving interim
interim decide.
protection to you. What?
interim হলে আপনি appear করবেন 10 days লাগবে না?
In the meanwhile, considering the submissions made by learned counsel for the petitioner, the petitioner shall appear before the investigating officer of Behali PS case number 141/2023 and shall cooperate in the investigation. Within 10 days from the date of this order. If he does so within the stipulated period of time, in the event of his arrest in connection with Behali PS case number 141/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 15th of December.
Right.
Mr. Chaudhary, Kohima is on 4th of December.
The 9th.
4th is the winter vacation
9th.
in Kohima. After it will reopen only after 14th. You choose a date as per
Yes, sir.
your convenience and inform us.
Item 48,
The lottery, my lord, 430 application, my lord, CD was called for, my lord.
CD is here. The only problem is that perhaps they were injured because of the assault. That injury report is not there. No.
Just a minute.
3-6.
Let me release Mr. Chaudhary.
18 January. After this. There already the January.
Okay. Okay, 18 January. Kohima, I think. Yes.
Yes, the charges were under 326 as well. But the doctor's report, the injury report is not here. I have not seen. Otherwise, the allegations that his vehicle has hit someone else's vehicle and there was a fight. That is their statement. That is there in the statement of other witnesses as well.
And during that fight, the injury.
Someone got grievous injuries and all. That injury report is not here.
My lord, the informant has sustained injury in his left eye, my lord. That was not severe injury, my lord. Some stitches has been done, my lord. And the petitioner is the driver. His vehicle was standing nearby parking place, my lord. Informant's accused vehicle, my lord.
How many accused are there?
Four accused persons named after, my lord. This present petitioner is accused number 2, my lord.
What has happened to other petitioners?
My lord, one accused person was picked up by the police, but later on he was released. For other accused, I have no information, my lord.
And
No specific allegation against the present petitioner. Ganesh Das.
Ganesh Das.
In the statement of the witnesses.
Ganesh Das. In the statement of witnesses, I can't. No specific on Ganesh Das. They came and attacked. This is what I found. Bujai Thakute teo luke oslil bhakare gali pare aru marpit kore. Then same is Ganesh Sarkar ase nahi Ganesh. Is Ganesh Sarkar also?
Ganesh Sarkar. His actual name is Ganesh Sarkar, but in the FIR his name is written as Ganesh Das.
Ganesh Sarkar, this is Saidul Islam statement. I think he is an accused, no?
Yes, yes.
Saidul Islam has stated. Now, he had stated about Ganesh Sarkar. It is only not in this statement of the witnesses, but the accused. Ganesh Sarkar. In fact, one of the witness, Jagabandhu Mondal, he said, বাহনত সামান্যভাৱে লাগি যোৱাত উক্ত গাড়ীখনৰ ক্ষতি হোৱাৰ বাবে সাইদুল ইছলাম, মতিবুৰ আলী, গণেশ চৰকাৰ, তফিকুল, নাদিম আহমেদ টকা দাবী কৰি তৰ্জন গৰ্জন কৰি থাকোঁতে মনদীপ সিংহই তেওঁলোকক বুজাই থাকোঁতে হঠাৎ উক্ত সাইদুল ইছলাম, গণেশ চৰকাৰ again, they had started giving, scolding them with bad language and গালি গালাজ পাৰি ভাবুকি প্ৰদান কৰে আৰু গণেশ চৰকাৰ, তফিকুল, নদীম and so মাৰ ধৰ কৰি চকুৰ কপালত জখম কৰে. This is stated similarly by other witnesses also. Jahangir Alam, Ganesh Sarkar, so টকা দাবী কৰি মাৰপিট কৰে.
Now, what is your submission? Should we wait for the,
In fact, their names are specifically taken, Ganesh Sarkar's name. He had injured also.
no,
on
therefore
API.
the nature of injury is relevant.
That is not there in the injury report. I'll have to again bring.
Let us wait for injury.
My lord, he may be protected, my lord. Petitioner may be protected.
He's already on interim.
No. He will appear before the IO, my lord.
Heard Mr. S. Das, learned counsel for the commissioner, also heard Ms. S. Jahan, learned additional public prosecutor. Learned additional public prosecutor has submitted that though in pursuant to the directions of this court, the case diary has arrived. However, same is not accompanied with the injury report of the victim. Mandeep Singh, who appears to have sustained injuries on his left eye. This injury with sharp weapon over left eye. Who caused this injury? No specific.
No, all the four. Ganesh Sarkar, Sahed Ali, everyone. 4 of them, I think. 4 of them.
No, left eye injury must have been caused by
Left eye injury. I've just read out this. কপালত মাৰি জখম কৰে, and this was by all 4. Nadim Ahmed, Tawfiqul.
Now, what is your submission?
My lord, this present petitioner is a driver by profession. His vehicle was standing nearby market, my lord. One vehicle came all for unloading some materials of the informant. Suddenly that vehicle hit on parked vehicle. That's why some altercation took place, my lord. So many people are there, my lord. So the petitioner came out and he tried to ease the tension, but some altercation took place and he sustained injuries, my lord.
Petitioner sustained injury.
Not petitioner, my lord, the informant.
You assaulted.
My lord, the petitioner submission, petitioner statement is that he was standing nearby market, my lord, with his vehicle. He was not involved, my lord, but his name is given in that.
Sure. What was the last name? Learned additional public prosecutor has further submitted that considering the nature of allegations leveled in the FIR, perusal of the injury report would be necessary for consideration of the instant bail application. However, she also submits fairly that though the injured appeared to have sustained injuries over left arm with a sharp weapon, left eye with a sharp weapon. However, nobody has been named specifically to have caused that particular injury.
All the four had done this
And
as well.
the allegations are leveled against
All the five.
all the five accused were named in the FIR. Considering the submissions made by Learned, on the other hand, Learned counsel for the petitioner has submitted that the present petitioner is an owner of a vehicle which was parked near the place where the altercation occurred between the first informant and other co-accused persons. And he was there at the place of occurrence only, witnessing the incident, and has not assaulted the accused persons as alleged in the FIR. Stop. Let the injury report be called for. However, in the meanwhile, considering the fact that from the evidence, from the materials in the case diary at this stage, it could not be found out as to who had inflicted the injury on the eye of the victim. Hence, the petitioner, namely Ganesh Sarkar, alias Ganesh Das, is directed to appear before the investigating officer of Tata Steel Ambari PS case number 266/23 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Tata Steel Ambari PS case number 266/23, the above named petitioner shall be allowed to go on interim anticipatory bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions. Number one, and let this case be case diary. What we will do, you will
I'll
send
send it back and I'll
let,
get the,
let the case diary be sent back to be recalled again after updation along with the injury report on
any day, 15th of December or 14th? Or later? 20th of December? Eh, Harry, Kamru, kya pe?
number of cases fixed.
Acha.
21.
21,
Let
Lordship,
it be
yes.
fixed on
This
21st.
is very, kota hi number hai?
Let it be on 21 December.
21, Lordship.
Item 49, along with item 1 of production list.
May it please, Your Lordship. Lordship will take up the IA first or the main. I think your turn. Lordship, in the IA, Lordship will be taking IA.
Okay.
In the IA, Lordship, I have filed one IA for correction in the cost title and in the body of the petition, Lordship. What happened? There is a typographical error, Lordship, section 354. B has been inadvertently typed out, Lordship, while typing the anticipatory bail application, Lordship. In the FIR, no such sections are there, Lordship. So while passing any order, Lordship, that may be corrected or that may be read.
Third, Mr. S.N. Krishna Preya, learned counsel for the petitioner. This interlocutory application has been filed in connection with the anticipatory bail application number 3858/2023, praying for allowing the petitioner to make certain corrections in the cause title of the said anticipatory bail application by what correction you are seeking?
Lordship, deletion of section 354B from the cost title, paragraph 2 and 12, and from the prayer portion of the main bill.
By only 354B,
Yes, Lordship, that section has been typed out wrongly, Lordship. That was not in the FIR, Lordship.
by allowing the petitioner to struck out section 354B mentioned in the cost title. As well as in prayer portion, what is
In prayer portion, Lordship, that section has been written as Gogong PS so under section so and so, that part, Lordship, only that section.
only 354B?
Others will remain, Lordship.
What was the last? Cause title, comma, prayer portion, as well as in paragraph number 2 and 12 of the anticipatory bail application. The learned additional public prosecutor does not opposes the said prayer, hence the prayer is allowed. Let this said how this correction would be made.
For the registry or Lordship, what is quote on the statement.
Registry will make corrections by hand. No, you have to file a corrected amended petition then
Lordship, on
making those corrections. This prayer is allowed. Now you have to file an amended petition on record. Where
only one part, Lordship, that can be struck off, Lordship.
no, because of a
In earlier occasions, I may be wrong, Lordship. On earlier occasions, Lordship, that struck off is allowed by in earlier occasions, because at that time, Lordship, this is
the registry shall strike out section 354B wherever it appears in the anticipatory bail application number 3858/23. This anticipatory application is accordingly allowed, accordingly disposed of.
Lordship, main AP, Lordship.
So 354B is to be deleted.
Yes, sir. Yeah, typography, sorry on my part, Lordship. I apologize for that, Lordship. Some copy paste sort of thing, Lordship, that's right. Anyways, Lordship,
Yes.
here, Lordship, the petitioner and the informant, admittedly, there was a love relationship between them, Lordship. And for that, Lordship, one meeting in the village has also been occurred, Lordship. And thereafter, they are not in relationship. Subsequently, on 1610, Lordship, the husband of the informant assaulted the petitioner, Lordship, and thereafter family members also assaulted the informant. And under the instigation of the family, Lordship, the wife of the informant, Lordship, lodged this FIR, Lordship. That is the case, Lordship, and for which, Lordship, the petitioner, Lordship, apprehending arrest, Lordship.
But allegations are grave.
Allegations are given, but Lordship, those are not true. That I am not, as per my information, Lordship, I am having my minor child and old aging mother, Lordship. I have to maintain them also, Lordship. And admittedly, there was a relationship, but at this stage, Lordship, we do not have any relationship. And Lordship, earlier it is consented one, Lordship, which is evident from the statements of the all the husband and wives given before the, Lordship, meeting held in the village, Lordship, which was The vernacular lordship will find at page 15, which is duly endorsed by the village headman also lordship. In presence of several persons lordship. Admittedly, there was a love relation in the earlier part lordship, but this affair has been lost.
Yes, Mr. Sharma.
Yes, my lord, from some villager statement is there, my lord, they have some relation, my lord, earlier, and some village meeting also held. But my lord, in 164 statement, my lord, present petitioner was, my lord, implicated. And my lord, she is major, my lord, she is the wife of the married lady.
When the offense occurred,
My lord, that is also, my lord, according, my lord, her 164 my lord, যোৱা 14-10-23 তাৰিখে ৰাতিপুৱা 7 বজাত মই গৰু এৰাল দিবলৈ পথাৰত গৈছিলো। গৰু এৰাল দি আহোঁতে মোৰ
but
গাঁৱত
in the FIR, the allegation is
1610.
on 1610.
yes, my lord, there is 1410, my lord. Exactly. 1410.
And
আমাৰ গাঁৱত পূৰ্ণকান্ত মোদক নামৰ ল'ৰাজনে মোক মুখত কোপা দি ধৰি নি বাহনীলৈ লৈ গৈ মই জবৰদস্তি ধৰ্ষণ কৰিছিল। মোৰ হাত ভৰি বান্ধি লৈছিল। তেওঁ মোক পিছদিনা গধূলিলৈ তাত ৰাখি থৈছিল আৰু সেই সময়ছোৱাত 4 বাৰ ধৰ্ষণ কৰিছিল। পিছদিনা মোক বাঁহৰ লাঠিৰে কোবাই তেওঁ বাহনীত মোক এৰি থৈ যায় আৰু মই কিবা কিবি কৰি তাৰ পৰা নিজৰ ঘৰলৈ আহোঁ। মোৰ ক'বলগীয়া ইমান। Injuries, my lord, as is in her statement, my lord, there is nothing, my lord. But my lord, injury report is not here, my lord, in that case there. But according to in her statement, my lord, there is no mention regarding any injury. That my lord, that she was assaulted. That is there. The bahar lathire popai.
What is the subject?
Lordship, for a moment, lordship peruse the FIR lordship. The 164 statement and the FIR are complete contradictory lordship. In the FIR, her statement is that her FIR lordship that in the morning she left from the place and she was assaulted by a petitioner has slapped him. Lordship will find the particular case 13 lordship. Means to since lordship there is a contradiction lordship in the FIR in the 164 statement for given to the administrator lordship and the LS date is also wrongly submitted because lordship the entire incident does not happen only because only the thing on 1610 lordship the husband of the informant
No, when she was medically examined.
Actually, my lord, that regarding death, my lord, not mention, my lord. And on my lord, police note also, my lord, date is different. On 1510, in the morning, the victim, while went to gaze cows, the accused slept in the face and forcibly taken to under bamboo bushes and keeps her for the whole night with him and raped 4 times. That is the date is now, my lord, is 15.
And as per my knowledge, those lordship, my petitioner, as per the information of petitioner, there are no cows in the home of the victim lordship. That I could not submit because that I have not stated also in my petition because I don't have any proof. But
Now, why the victim should be disbelieved?
yeah.
What are the grounds?
But lordship, the dates. Firstly, the dates, lordship. Secondly, the FIR when the FIR was stated, lordship, there she has stated in the morning, and as per her statement, lordship, the petitioner slapped him. slept heard lordship. And in the 164 statement lordship, which reveals contrary to a lordship in the evening and with a stick.
In
lordship.
164, what she has stated?
In 164, my lord, he has stated that on যোৱা 14-23 তাৰিখে ৰাতিপুৱা 7টা বজাত মই গৰু এৰাল দিবলৈ পথাৰলৈ গৈছিলো। গৰু এৰাল দি আহোঁতে আমাৰ গাঁৱত দিছ পাৰ্চন মাইল মোদক নামৰ ল'ৰাজনে মোক মুখত সোপাদি ধৰি নি বাহনীলৈ লৈ গৈ মোক জোৰ জবৰদস্তি ধৰ্ষণ কৰিছিল। মোক হাত ভৰিত বান্ধি থৈছিল। তেওঁ মোক পিছদিনা গধূলিলৈকে তাত ৰাখি থৈছিল আৰু সেই সময়ছোৱাত 4বাৰ ধৰ্ষণ কৰিছিল। পিছদিনা মোক বাঁহৰ লাঠিৰে কোবাই তেওঁ বাহনীতে মোক এৰি থৈ যায় আৰু মই কিবা কিবি কৰি নিজ ঘৰলৈ আহোঁ।
Now, what is the submission?
My lord, that some my lord variations are there, my lord. But my lord, 164 statement is 164 statement, my lord. And my lord, she was my lord medically examined because my lord in the IO, my lord said my lord, I have to collect medical report. So my lord, it is
Let
yet
the
to
medical
collect.
report be.
In the meantime, I be protected lordship. Since there are conditions, let my statement also be recorded lordship. Then the clear picture will come lordship. No
Let
one.
medical report be collected.
Well,
In
She
the,
has been medically examined.
examine, my lord. Though my lord, date is not mentioned here, but my lord, IO has said that it is to be collected. That's why my lord.
Okay.
Certain
Heard Mr.
SN.
S.N. Krishna. Yeah, dictation is still on it. I have started dictating. Heard Mr. S.N. Krishna Traya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Purno Kantam Medok, who has been apprehending his arrest in connection with Gogamukh PS case number 105/2023 under section 366/376 within bracket 2 within bracket small n /323/3506 of the Indian Penal Code. The gist of accusation against the present petitioner is that the victim/informant of this case had lodged an FIR on 15/10/2023.
17.
No, FIR has been lodged on 15.
16.
It is not 16. Though in
SMS.
translation you have.
No, lordship, in the origin one lordship, it seems to be lordship.
Sorry. Lodged an FIR on 16/10/2023, inter alia alleging that on the morning of 15/10/2023, the petitioner had forcefully committed rape on her by dragging her to near the bamboo group and keeping the victim there since next day evening. It is also alleged in the FIR that the first informant was threatened by the petitioner not to disclose about the incident to anyone. Learned counsel for the petitioner submits that earlier the petitioner and the victim were having an affair, and in this regard, though that no, were having an affair, though the victim is a married woman. It is further submitted by learned counsel for the petitioner. In this regard, a village meeting was also held on 21/6/2023. 23. What was decided?
But if that if in the meeting, it is decided that from that day onwards, both the parties will not have any relationship.
From
And-
that day onward, both the parties shall not have any relationship.
And statements were recorded from both the husband and wife. Of
Yes, that is supported by the case.
And in that village meeting, the statement of the victim as well as petitioner as well as their spouses were recorded. Now your submission is that this affair has been falsely lodged.
Yes, Lordship.
Why?
Because on previous day, Lordship, the husband of the informant, Lordship, assaulted the present petitioner, and to safeguard his own skin, and the informant was also assaulted by the husband of her Lordship, her husband.
Stop.
As per
Learned
this,
counsel for the petitioner has submitted that the allegations made in the affair against the present petitioners are false and have been made by the victim only under pressure from her husband, who had on the previous day of lodging of the affair had assaulted both the petitioner as well as the victim.
previous day assaulted the petitioner, Lordship, as my
And
informant. Victim on the day of allegation, because he told that I will not be lodging any affair, so that's why she has been assaulted in the
assaulted the petitioner on the previous day. It is also submitted that the victim was also assaulted by her husband on the day when she lodged the affair, as she was reluctant to lodge any affair. It is further submitted by the learned counsel for the petitioner that even the dates of the alleged offense have been mentioned differently by the victim in the FIR as well as in her statement made under section 164 CRPC. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the trial if he is allowed to go on bail under any condition. On the other hand, learned additional public prosecutor submits that considering the nature of allegations leveled against the present petitioner, the medical report of the victim girl would be necessary. It is further submitted that though from the case diary it appears that the medical examination of the victim girl was conducted, however, the investigating officer is yet to collect the medical report of the victim girl. It is further submitted by learned counsel for learned additional public prosecutor that there are materials in the case diary to indicate that the victim and the petitioners were having affairs, were having an affair prior to the alleged incident, and in this regard, a village meeting was also held. Considering the facts and circumstances of this case, let the case diary be sent back for updation and let it be produced again along with the medical report of the victim girl on 21 December 2023. In the meanwhile, considering the facts of this case as well as submissions made by learned counsel for the petitioner. The petitioner, Shri Purnakanto Medok, is hereby directed to appear before the investigating officer of Gogamukh PS case number 105/2023 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Gogamukh PS case number 105/23, he shall be allowed to go on interim anticipation of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions. Condition number 1 and with above observation. Now, let this case be listed again on 21st of December for updated case diary along with in medical.
Deeply obliged.
56 of the supplementary list.
Obliged.
May I please, your lordship? Lordship, on the last occasion, lordship, issue had arrived whether the petitioner has appeared before the High Court.
And Saha Ali, they are searching, but I think Ajibor had given his statement. So there are two petitioners here. Ajibor had given his statement, but Saha Ali is yet here. His house was searched.
Here, Sahali has not.
Lordship, interim protection was provided to both the petition, and accordingly, after obtaining the certified copy, both the petitioners appeared, your lordship. Lordship, may kindly see one order dated 17/8/23 in this passed by this honorable court.
Saha Ali statement, I don't.
Lordship, may kindly be pleased to see the order 17/8/23.
Yes.
It appears that on 21/7/23, when the case diary is produced, it was also not updated. The case diary as produced today has last entry of 17/5/23. Where is the interim protection was provided on 12/6/23.
Here, last stipulation is 20th of October 23.
Before there also case diary was published.
But as on 20th of October 23, Saha Ali's statement is not there.
And the petitioners appeared, lordship, on from 20 to 23rd of June. So by that time, the earlier case diary was already discharged.
Produces that?
23rd June.
23rd June. From May, I see it's October. From 17 May 23, it is October. Lordship can just have a look, subject to correction. And this is Ajibar, there is a statement. But Lordship can just jot it one. Where is it?
One SR Monjil Borgo hai recorded that statement.
June or February? Putor May from October. So what happened to those? From May, I could see things goes to October.
Lordship, our interim protection was first granted on June. We appeared within the stipulated time. And there was no entry in the case file since May 17. Petitioners appeared.
What is your name? Saha.
Saha Ali and Ajibur Rahman, two petitioners.
Ajibur, I found his statement. Saha Ali, I did not. Postmortem report is there. Postmortem report shows it is a case of suicide.
It's a case of suicide.
Because the ligature mark is non-continuous, there is a knot. It is high up in the thyroid, above the thyroid. So looking into that contents, it seems it is suicide.
Then let him appear.
Lordship. And
Yeah.
I'm wondering, I wonder why these the entries are not there from May to October. Let him appear to who say no, according to him.
Appear with it. One Ainul Haq stood as a bailer.
Maybe they have maintained another 5.
What is the name of the petitioner? Sahali or Samed Ali?
Saha Ali. Elias ki ba asan chika? No. Samed Ali mo pasha.
Because father's name is same.
Acha.
No, Saha Ali and Azibur Rahman. Saha Ali's father name is Amjad Ali.
Amjad Ali. Samed.
And Azibur father name is Muqtada Ali.
So Samed Ali's father is also Amjad Ali.
Yes.
Oh. But then there is no Elias or Saha Ali.
Okay, in view of the fact that the postmortem examination report suggests
Hmm.
that it is a case of suicide,
Suicide.
let him again appear
Not-
if required.
If required.
Sahali has to
Hmm.
appear again. We are disposing of this matter.
Yes.
Hmm.
Heard Mr. M. Ahmed, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor, who has produced the case diary of
Because our PS case number 180.
Sipajar PS case number 183/2023, and has submitted that though the case diary suggests that the petitioner, namely Azibur Rahman, Azibur Rahman has appeared before the investigating officer. However, there is nothing to indicate that Saha Ali has appeared before the investigating officer. On the other hand, an additional public prosecutor submits that both the petitioners, namely Saha Ali and Azibur Rahman, were granted interim anticipatory bail by this court by order dated 12/6/2023, and thereafter, as per submission of learned counsel for the petitioner on 23/6/2023, both the petitioners appeared before the investigating officer, and their statement was also recorded by one Manjul
Borgohai.
Borgohai,
Manjil Borgohai.
Manjil Borgohai, SI of police. However, on perusal of the case diary, no such statement could be found there in the case diary. Stop. Learned additional public prosecutor has submitted that otherwise from the post-mortem report examination, it is found that continuous ligature mark
Only one thing, hyoid bone is intact. Otherwise, hyoid bone also gets broken.
crushed.
But then the other things are towards suicide.
The,
Lordship can see that.
the
I can take it out.
post-mortem examination report suggests that this is a case of suicide. And in view of the case of suicide, I have considered the submissions made by learned counsel for both the sides and have gone through the materials in the on record, including the case diary of Sipajar PS case number 183/23. Considering the fact that the petitioner, namely Azibur Rahman, has appeared before, considering the fact that there are materials on record to show that the petitioner Azibur Rahman has appeared before the investigating officer in pursuant to the directions of this court, the interim anticipatory bail granted to the petitioner Azibur Rahman by order dated 12/6/2023 is hereby made absolute, with condition number 2, 3, and 4 attached to the said order remaining intact. As regards petitioner, namely Sahal, is concerned, though nothing is available in the case diary, however, considering the submissions made by learned counsel for the petitioner that the petitioner Sahali has appeared before the investigating officer on 23/6/23, that is immediately after he was granted interim anticipatory bail by order dated 12/6/2023.
Most family lordship, he has been appearing since 20, and finally he as per the instruction. His statement was taken on 20. He appeared from now 20 or
23. Also considering the fact that the prima facie, it appears from the postmortem examination report that this is a case of suicide. The interim anticipatory bail granted to the petitioner Sahali is also made absolute, with a condition that he shall again appear before the investigating officer of Sipajar PS case number 183/23 within a period of 15 days from the date of this order, so as to facilitate the investigating officer in recording his statement under section 161 of the CRPC if he so desires. With above observation, this anticipatory bail thereby disposed of. Send back the case.
keep your place.
57,
57, Lordship wanted us to take the instruction as to whether the accused statement was recorded by the police. Now, it is being informed that yes, his statement was recorded and he appeared and he was recorded. This is the human trafficking case.
Third, Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public
S. Jahan.
prosecutor.
S. Jahan.
Oh, sorry.
Lordship is habituated in taking.
It has been mechanical.
Yes, it's a mechanical, it happens.
Also heard Ms. S. Jahan, learned additional public prosecutor, who was requested by this court by order dated 23/11/23 to take necessary instructions from the investigating officer as to whether the petitioner, namely Maina Devan, had appeared before the investigating officer after she was granted interim anticipatory bail by this court on 26/9/23, and accordingly, an additional public prosecutor has submitted that she has been informed by the investigating officer that the petitioner Maina Devan has appeared before the investigating officer. Her statement was recorded
Yes, it was recorded.
and her statement has also been recorded by the investigating officer. Considering the fact that the petitioner Maina Devan has appeared before the investigating officer in compliance with the directions of this court and has cooperated with the investigating officer, the interim anticipated bail granted to the petitioner Maina Devan by order dated 26/9/2023 is hereby made absolute, with the condition that the petitioner shall continue to cooperate with the investigating officer of Tarabari PS case number 68/23. With above observation, this anticipated bail application is thereby disposed of. Send back this.
Highly obliged.
58.
Same in the case with eight. But
58 also,
here, but here does, what we do is we tell the office person to get the instruction and he writes it there. After taking instruction, he writes in the file. And he writes here, appears statement recorded. I have to take another instruction or he has the
No,
proper.
he appeared, my lord. That's what I told them, my lord.
Whether it is written now.
It's written appears statement recorded. I have not spoken to the IO. No, CD there is none
It is
because
nothing, my lord.
because
Your
CD
lordship
is
has
retained.
to take a telephonic instruction.
Telephonic instruction. CD there is nothing. It's
So, instruction is my instruction also. I appeared. I give this all the state document.
because in the earlier file, it's written, yes, she appeared, statement recorded. I have been informed by IO. Such nice line. Here the line is appear, statement recorded. So
Shorthand.
appears. So
But whether he is reliable.
this is what, then let me take the instruction today, tomorrow. Then, okay.
They are
No,
officially.
it is your office staff.
Our office staff. I because I cannot rely on this. Just see this statement.
No, this is not good. You know. Your office, your colleague. You know.
Yes.
You cannot
No,
say-
let her, because instruction was to the public prosecutor.
Yes. So
to
I'll just clarify this. and
Because
I-
there are instances where even the IO does not give proper information even to additional public prosecutor or public prosecutor. So when the
problem now, what has happened? Tomorrow again, Mr. Dilip will not be there.
No, I'll be there. I take responsibility. I'll be there. Mr. Julie will not. I'll be there.
third, Mr. P. Bora, learned senior counsel assisted by Ms. K. Sharma, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, who submits that she may be allowed some more time for seeking instruction over telephone from the investigating officer to ascertain the fact as to whether the petitioner has appeared before the investigating officer in pursuant to the directions of this court by order dated 5/10/2020. The prayer is allowed. Let this case be listed again on,
Tomorrow?
no,
At 2 o'clock, only just one line, because otherwise,
at 2 o'clock.
At 2 o'clock tomorrow.
tomorrow 2 o'clock, my lord, because only that whether I have.
Only the telephonic instruction I'll take. So
Okay.
even today I could have taken. but
Tomorrow, that is
tomorrow.
on 29/11 at 2 o'clock,
2 o'clock.
2 p.m.
2 p.m. I'm obliged, my lord.
For admission, item 15.
May it please Honorable Court, my lord. The petitioner here is a seasoned senior bureaucrat. And she comes here with a grievance, my lord, in if my lordship would be kind enough to turn to page 35 of the petition.
at Annexure 4.
No,
Is my lordship with me?
before you start,
My lord.
just a gist of the case. Why have you?
My lord, somewhere down the line, there was an FIR filed by a gentleman called Dulal Bora. And subsequently, there was a bureaucrat called Rajesh Sinha who instructed that the vigilance cell file an FIR. So respondent 2 was the informant. Now, this alleged that there was by the petitioner before my lordship, there was an order signed in the year 2006 when she was for 6 months, over a few days in November, she allowed a mutation. Now,
Who is the petitioner?
the petitioner, my lord, is a senior
Yes,
bureaucrat.
officer.
The senior bureaucrat, my lord, presently attached to the governor's house as well as secretary level, my lord. She's been highly recommended by her peers and the administration. So this case, whatever the findings of the IO was, has not affected her accession of public service. But what has happened is like the period when she had made a note, she said that she is not the authority to grant a mutation. The matter may be placed before the circle officer or the SDO or the DC. And that was taken up also by the Lat Mandal of the circle. You know. Then she was in 6 months transferred to the GMC.
She
didn't have the power to give the mutation. She never gave mutation.
Okay.
Now what happened?
At
That was in
that
2000.
time, in what capacity she was?
She was in what they call attached in charge of the circle office, while the circle office, the regular circle officer had not been appointed. Thereafter, my lord, she was transferred to the GMC as there was some sort of a sporting event held in the city of Guwahati. So she was put in charge of that.
Okay.
Now what happened, my lord? After she left in 2006, in 2014, this Dulal Bora and this Rajesh Sinha and all these people started this thing. And the FIR was lodged. The investigating officer was appointed. Investigating officer then wrote his PRC and proceeded to retire. In the PRC, as hypothetically, I'll take my lordship to the regular paras where he's mentioned. He has hypothetically said what she ought to have done as a person in charge of the office. No prima facie evidence. It is as if I would be telling my lordship how to do the job. And written as accused, but within brackets, no evidence found. Further investigation needed. Thereafter, the scanned copy of the lower court record brought before my lordship. No permission to do a further investigation has been taken. In fact, the SP who's in charge of the CM's vigilance cell has written a letter that the IO has retired. The IO has retired. Now, the proceedings in the lower court, charge sheet has been filed, no charges are framed. There are 2
charge sheet has been filed.
As PRC has been filed, and there's been no charges framed as yet. Not against me, but in the charge sheet, I have been listed as an accused with no evidence against me.
Okay.
So that sword of Damocles is over my neck. Others who are in that same capacity have retired from service.
When the charge sheet was laid?
I'll take my lordship to Annexure 4.
Now at what stage has it been stayed?
No stay, nothing, my lord. In fact, the other accused are also not appearing. The other accused are also not appearing. Only one accused has been additionally added. His 164 statement has been recorded, has been placed in a sealed cover. He now on the last date said he wants to have a confession. The court disagreed, saying that we'll record your statement, but we will not record it as a confession. So that has nothing to do, is neither here nor there as far as I'm concerned, because his concept of confession is after the year 2014 of events happening in 2014 onwards. So if I had done something in 2006, I would not be connected to 2014. Subsequently, on inspection of the lower court record, I have come across 3 letters issued by the governor's office that this land, so-called land, government land or whatever land, is to be given in the name of the particular companies which is supposed to have taken this land illegally, apparently. Governor's letters are there on record, my lord. The IO has not even seen it. And I don't know why I am listed as an accused. If your lordship would be kind enough to bear with me.
Okay.
I'll take my lordship to page 44.
No, charge.
Column 11.
No, before that, let me further understand. The charge sheet has been laid under section.
I'll take my lordship at page that my lordship would find at page 35. Charge sheet number 3 of 2021, dated on 6th of July 2021. These 119, 120B, 167, 420, 488, 471 IPC, 13(1)A of the old amended PC Act. Date of the FIR shown as 28th of May 2019. Now, what they have also further done is that the earlier FIR lodged by Dulal Bora has been merged with this FIR. And that perhaps my lordship would find in the scanned record.
Okay.
Now, in this case, I was neither arrested nor was I detained. I gave my statement. Now, please come to page 44. Column 11 of the charge sheet. Now it says particulars of accused persons not charge sheeted oblique suspect at sub-column 1. I'm accused number 1. And my name is there. ACB.
Oh, so you are not sent up for trial.
I have been listed here as a. Now, please come further up to page 45. At sub-column 18. Any other important remark for not charge sheeting? Evidence insufficient. Now, please come further up, my lord.
So how you are aggrieved?
My lord, they are asking that the matter at page 17 B. I'll just take my lordship to that. So she would bear with me because at page 56. If my lordship is with me at page 56, may I lead my lordship to that column?
56.
My lord. It's at column 17L. May I read my lordship? May I lead my lordship?
Yes.
It appears on investigation that even though the concerned Lat Mandal so-and-so mentioned in the prescribed column that Assam Sarkar or RSS so-and-so dated 6th of June 2005, no Sithir Hukum Mute Patan Hua Jami, pardon my pronunciation of the word.
No.
Yet Sri so-and-so, the petitioner, the then attached circle officer, Dispute Revenue Circle, passed no remark on specific column of circle officer and simply forwarded the matter to the office of the DC Kamrup for necessary action. If the said CO passed specific remark regarding condition pertaining to the transfer of newly settled land as imposed by the government, probably the seller would not have been able to manage the officers of the DC Kamrup M and others. It may be noted that so-and-so, the then CO dispute, from attached CO have become CO. Forwarded necessary records for sale permission of land of 2 bighas of land, but permission was accorded for 7 bighas of land. Now, that is not in my authority to pass the mutation. So further investigation, he's mentioned, should be taken up. That is his recommendation as the IO. Permission for further investigation has not been given by the senior superintendent of police of the vigilance cell, nor by the court. So I'm just left. I don't know whether I'm listed as an accused. I don't know whether there's going to be a proceeding against me. My name should have not even come here.
No, suppose what is my understanding? There are the 5 numbers of accused named in the FIR.
Miller.
Investigation is, after investigation, evidence is found against 3,
Miller.
against 2, insufficient evidence is there.
Precisely.
Then against those accused against whom no evidence or insufficient evidence is there, they will be shown as not sent up for trial due to insufficiency of evidence,
But here
which has been the case in the instant case.
in this instant case, I'm still listed as an accused. When I was not even concerned with the matter, it is 2005. The FIR is in 2019. This is an open-ended investigation. It has not been closed within the 90-day period or the 60-day period, depending on the sections I read out to my lordship. How can you keep an investigation open-ended, Miller? Will there be no end to the investigation? Will there be no logical conclusion? Would the prima facie evidence not surface? On what basis will the court proceed? I'll still be listed as an accused. And that will be to the benefit of whom? It will be to my shame. And it will be against my career, whatever career I have left in the government. It will be a sword of Damocles hanging over my neck, slowly slicing me to pieces.
No, how? Because
Every time-
no material is found against him.
Every time the matter would come up for my service consideration, they'll say that this case is pending, you are still listed there as an accused. How will they understand, my lord? My lord would understand that, okay, I'm listed there as an accused, but no evidence is found against me. But on the administrative side, on the bare reading of the materials, it comes to mind that you are still an accused. What the police are doing and the police are doing, forget about the police diary, forget about the CRPC. You are still an accused. The police diaries and the CRPC are very exact. If you have materials against me, kindly list them. I'm entitled as an accused to know what materials you have against me. They don't have any material against me. They are hypothesizing. As an accused, my lord, I am entitled to all the materials against me. My friend, who is the public prosecutor, also has to provide the same to me. If it's in my benefit, he cannot hide it.
Yes.
On a plain speaking matter, my lord, I don't know what the present situation of the police is, my lord. But there was a time when any matter that was in favor of the accused was produced and given to him, so that he could make his defense. And that has been the ethical annals
No,
of
no.
jurisprudence.
One query.
Miller.
What is your relief which you are seeking?
I am seeking that my name be struck off this as an accused, my lord. The matter be, the CRPC be followed, let the matter be closed against me if necessary. Depending on whether there is a further eye on the scanned copies before my lordship. I have, my lord, various letters from the governor to various settlement officers at this particular land. I can produce them to my lordship. I can point
No,
them out
that is-
from the
that is
record.
not required because IO has himself not found anything against.
IO has not found the file, my lord. There is no file pertaining to any allegation of me. He has gone, I myself have filed an RTI saying that if you have given me a show cause notice, kindly give me the documents on which you are alleging that I'm supposed to have manipulated. The reply from the RTI application is that no such file is available in this office. So on what basis is the IO making his hypothesis?
What IO is saying?
IO has simply reverted that no evidence has been found against me.
Apart from that, any other thing?
Apart from that, page 57, 17Q, if my lordship would come. Evidence collected against suspect officer, so-and-so, 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 is noted at point 17L. If my lordship is with me, if I follow my lordship's pencil, are we on the same paragraph?
Yes, yes.
17L, 17M, 17N, and 17O above have been analyzed at this directorate, and it was decided that the evidence collected so far against the above mentioned SOs are not prosecutable evidence. any efforts may continue against the above named government servants. What is the evidence collected against me? I'm asking you. I'm not getting this answer, but it's noted there at page 57 in column 17Q.
Okay, you are agreed with
I am
this
agreed, my
obser-
lord, by this.
this observation that
My lord.
efforts may continue
Lord.
against.
My lord, and then my lordship would come to 17S. The honorable court may kindly summon the witnesses mentioned in column no showing above. 17R says, prayed that in the light of averments herein, documents and other materials filed with the police report under 173 2 CRPC, the honorable court may kindly take cognizance of offence under this section, my lord, committed by the accused Jamni Talukdar, private citizen. Then Dilip Kumar Kalita, private citizen, not a single government servant. So how is the PC Act coming? What has now kindly come to 17T? If my lordship would jump with me to 17T briefly.
P.
D. T for Telangana. Page 57, last paragraph.
Yes.
During course of investigation, along with the role of government servants, namely so-and-so, petitioner before my lord, so-and-so, so-and-so, and so-and-so not petitioner before my lord, the role of so-and-so of, this is another accused which has been now taken into custody by the police, has been surfaced. But due to lack of prosecutable evidence against them, to face trial in the instant case, the government servants petitioner before my lordship and the others who are named there could not be forwarded at this stage for standing trial. Efforts are on to collect credible evidence against them. Can you manufacture evidence, my lord, is a question I put to myself. In view of the above, investigation will be continued as per provision of section 173(8) to collect further evidence against them. Where is the permission, my lord? Permission is required by the supervising SP. If you come to the last page, my lordship will see there is no permission extended. 173(8), no permission extended. But there is a prayer to take cognizance of the offences committed by the accused as mentioned above. I am an accused. How can you take cognizance of the offences against me? Be more specific, my lord. I've been just jammed together like any mixed up case with everybody else. Where is the equity in that? Where is the separation of the offences against the accused? That is what has come before my lord.
Okay.
This is totally a mixed jam.
So you are also aggrieved with the observations made in para 17T
My lord.
that further investigation would be continuing against you.
Because this is from 2021, we are now in 2023. If my lordship had in 2021 had this matter before him, my lordship would have directed that let the matter be finished in 2 months, 1 month, 30 days, whatever. But neither the police has been lackadaisical. The trial court has been lackadaisical. The investigating officer has retired. His successor investigating officer has not proceeded in the matter. The supervising SP has not done anything. There's been a total failure of following the statute, my lord.
Now, whether further investigation is going on, because in the case, in the PRC case where the charge sheet has been laid,
my lord,
nothing is going on against you.
Nothing against me, nothing against the others also.
You
The
are,
other two named accused at column.
you are
18.
apprehending that as further investigation is going on, at any moment something may come up against you.
My lord, I am now 58 years old. By the time they finish this, I'll be 69 years old. So either we finish it today, my lord, and you tell me, do I go to jail or do I stay outside? But when I'm an old doddering grandmother, please don't tell me to go to jail for something I have not done, which I'm laying before my lordship in a very plain, blatant, blank way. If I've done something wrong, I'll be the first one to be before my lordship and say, yes, I'll stand trial. There is no material to stand trial for me. But as my lordship knows, the wheels of justice move very slowly. One cog at a time. At 70 years old, I don't want to go marching to the jail, my lord. Lordship knows the jail here is capacity is 2,000 people, there are 8,000 there. How can we survive there at that age, my lord? Either we sort out this matter today, tomorrow, day after, any date as per my lordship's convenience, or he should have sorted it out 2 years ago. But keeping it this way, hanging like a nail poised over my head to split my skull. Why should I bear this, my lord? The sheer agony and torture is not what justice and equity and CRPC and the IPC or the PC Act has been made for, my lord. Neither have I got any materials under the PC Act against me.
Are you relying on any authority?
My lordship, if we have to go into that, there'll be authorities by the ton. I can provide that a list to the court master along with the copies. But
no,
if my lordship, I'm just going immediately. I'm playing entirely on facts, and I'm playing on my lordship's wisdom. If I have to go into the nitty-gritties, then we'll talk about Shashikala's case. We'll talk about Jayaprada's case. On the materials in those cases, how it was analyzed.
Only one authority on the point that
exact point I do not have.
Exact point
I do not have.
Let me put my query. When the petitioner is shown as an accused not sent up for trial in the charge sheet, the petitioner is aggrieved by the observation made by the IO in the charge sheet that further investigation would be carried out. You are aggrieved with this much is your grievance.
I carry my lordship a little further that no permission for further investigation was taken. That further investigation has not taken place at all.
Now,
either by the
now what order, what relief you want?
My relief is that I should not be here as an accused at all. I should be discharged. I should be the court below is not proceeding to even hear arguments under 226, 227. So how am I supposed to place these matters before the trial court?
No question of your facing a trial would come if something is found in further investigation.
In further investigation, which maybe even after charge sheet is charges are framed and filed against the other accused, but not against me. Later on, subsequent dates, suppose charges are framed against me, are we going to split the trial, my lord?
No, what is the law in this regard?
That's precisely where I'm stuck, my lord, because I not found an exact point by going through the CRPC again and again and again. I have not found a precedent to this case.
Because in any case where further investigation goes on as regards some of the accused person, their trial have to be later in time.
And there's a time limit. My lordship knows very well that it cannot be an indefinite period of investigation, which is what has happened here. 2005 and 6, they are alleging. 2019, they've lodged the FIR. 2021, they've lodged the PRC. And till today, the charges have not been framed. So are we at the PRC? They mentioned it as a charge sheet 3 of 21. They've given the date in July 21. But charges have not been framed. If the allegations in 2005 were true, I would have been convicted already. It's a long period of time. Sir.
Okay, you time is not left.
Miller,
you take me to that portion of your in the prayer portion where you are seeking the exact relief which
Miller,
this court may grant.
My prayer.
What you want?
Page 26. The lordship.
It is a long prayer. I need
Miller,
exactly
I'm taking,
what do you
set aside, cancel, expunge, and quash the name of the revision petitioner in charge sheet so and so at page 10 of 25 at column 11, titled a particular of accused person not charge sheet. Listed as subserial 1. I've outlined where I've been named as a particular person not charge sheeted, and I want my name expunged, including the status of not arrested is shown. So and so any other important remark for not charge sheeting evidence insufficient with charge sheet so and so arising from so and so corresponding to go to PS case number so and so filed by Dulal Bora. I've also said that the IO failed to produce any material evidence of fact against me, so it will be appropriate to wash my name from the case and allow the proceeding to continue in the manner prescribed by law under 482, that with 227 of the Constitution. So my prayer, my lord, is a little large, but it's very clear that I should not be in any court record if I am not having any evidence against me.
Okay. Then how the IO would show that against these accused persons nothing was found? How he will show to the court that again there are 10 accused persons, against 2 nothing was found, no material could be convicted. They have to be exonerated. Then what the IO would communicate to the court that against so and so, that has been communicated in this case.
My lordship is very right in allowing the IO to mention whatever he wants. But I will not say anything that will self-incriminate me. And I would take the benefit of remaining silent till he produces any material against me. I do not know what he has against me. That he has mentioned my name as an accused.
Okay.
If he has mentioned my name as an accused, he must be having some perimeteria. That has to stand the test of time. That has to be
Mr.
tested.
Borua, you have to reply not today.
My lord, I just, my lord, to reply only one question answer, lordship. As his application is not at all maintainable, lordship. Because this accused person has not been, my lord, sent for trial. Now, whenever if the trial court will file something, if the IO will file supplementary search sheet, then trial court will definitely issue someone. Then only she can, my lord, she can appear and file revision or quashing petition, anything, lordship. His revision is not at all maintainable. Lordship may see the prayer. He is all anticipating, lordship. Tomorrow this might happen, so this order may be passed today. Why? How can he stop the investigating officer from doing investigation, lordship?
We are also saying that he is anticipating that he'll find evidence.
That cannot be, lordship.
You cannot make an anticipation.
Let him satisfy on maintainability point, lordship. Then I'll submit, lordship.
What I'm saying
His
to
application
my
is
friend,
not
what I'm saying to my friend is, he is also anticipating. My lord.
My lord.
When would my lordship like to hear it again?
Heard Mr. P. N. Goswami.
Chaudhary, my lord.
Sorry, P. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. J. Bhojwani. Hearing remained inconclusive. Let this matter be listed again as part heard matter. When do you want?
When would my lordship is not clear next week.
After 8.
After the 8th of
8th
December.
of December.
After the 8th of
Because
December.
next week I'm not
My lord.
there.
After the 8th of December, which would be on any Tuesday or Wednesday. 19 is good. Yeah.
Kohima कितने? Okay, 19. Let this matter
19, 12.
Let this matter be listed on 19th of December as part heard.
Deeply obliged. If the matter could be taken up at 2 o'clock.
Okay.
Because I'd be grateful if that could be added, my lord, because
on that day you have to mention. We don't know what would be the list on that.
Because, my lord, I have some health issues, my lord, so I need to.
Okay, if you make such mention on that day, we will certainly allow.
I'm deeply obliged, my lord.
But today we are not passing.
I understand. I'm with my lord.
Regarding how many matters are? Regarding leftover matter, the court master will give the date. If any interim is there in any case, interim would continue.
Lordship, kindly, item number 15, and that may be listed for admission, Lordship. It is in our orders. 50.
Right. 50. Okay. Third, Ms. M. Dev, learned counsel for the petitioner, who requests that this matter ought to have been listed under admission column and has been wrongly listed in orders column. The prayer is allowed. Let this matter be listed in admission column. After one, after 2 weeks,
Yes.
after
Uh,
2 weeks.
May I please, your lordship, my lord, item number 59, Bhima petition, my lord. Some rise, my lord. Can it be possible there for tomorrow, my lord?
Court master.
My lord.